Test, test. This is the test. Hello, 1, 2, 3. 1, 2, 3. 856 Test, Mark. Test. This is the test. Hello, 1, 2, 3. 1. Auf Wiedersehen.
Good morning, everyone, and glad to have all of you all here today. We are going to begin with our first case of the morning, United States of America versus James Snyder, and we welcome Ms. Gambino. Good morning.
Good morning. Good morning, Judge Jackson, Akiwumi, Judge Hamilton, and Judge Lee. It is my privilege to represent James Snyder before the court this morning. And as you know, there were two trials in this case. We will be discussing issues from both trials. I will focus my presentation on the interference with attorney-client communications, with the violation of Mr. Snyder's statute of limitations with respect to the tax count, the inappropriate application of Section 666 to the case at bar, and also the violation of Mr. Snyder's statutory and constitutional speedy trial rights. We also have argued for the appropriate remedy in this case, which is a judgment of acquittal on both accounts 2 and 3, and that the district court has erred in each case when those motions were denied. So beginning with the attorney-client communications issue, this issue means that Mr. Snyder's case should not have gone to trial at all. The government interfered with the attorney-client communications in several ways. First of all, they filed a petition for a search warrant, a motion for a search warrant, and they did not include in that search warrant notice to the magistrate that privileged information and work product information would be included within the scope of their search and seizure. Secondly, they did not include in the warrant any time limitations or content limitations rendering their request overbroad. They did collect all of Mr. Snyder's Gmail accounts, both his personal and his professional emails.
Ms. Gambino, with respect to your overbreadth argument, I don't recall that being really pressed in the district court. Could you correct me on that?
Yes, Your Honor. It was pressed in the district court on several occasions. First of all, they argued at the time that this issue was presented that there were no time limits included in the search warrant, similar to the case in...
Sorry, they argued... Who's they?
Mr. Snyder's attorneys.
Okay.
Argued that there were no time limits in the warrant, and they compared the case to what happened in the district court in the Central District in the case of United States versus Wahi, where there also similarly were no time limits issued, and there were several other problems with that. The attorneys, the government attorneys in Wahi had recovered privileged information and ended up dismissing that case.
And with respect to the overbreadth issue, I would seem to present a Leon problem, since the magistrate issued the warrant and the government carried it out. Is there would you have a basis for overcoming good faith reliance on the scope of the search warrant?
Yes, Your Honor, because the magistrate who issued the warrant was not properly informed of everything that they were looking for, or that the attorney client privileged communications would be included within the scope of their warrant. So he did not have all of the information that he needed in order to make the decision.
Ms. Gambino, though, how would the government know whether or not a client attorney communications would be within a category of documents that they seek to seize? As a matter of course, do they need to just tell the magistrate, well, there's a potential, like in every case, that the seizure might include attorney-client documents? And if so, what practical impact would that have?
Well, Your Honor, in this particular case, there had been ongoing discussions with the attorney involved in the case that was representing Mr. Snyder at that time, over the period of about a year and a half, almost 2 years, there were communications going back and forth between the government and that attorney. There were several meetings with that attorney as that attorney was attempting to persuade the government to not prosecute Mr. Snyder. So they were well aware not only that Mr. Snyder was represented, but they were in communications with the attorney, and they would follow up with issues. The government would raise issues, his attorney would then come back and address those issues, and that process was continuing throughout this time period. So it is not always the case when somebody's being investigated for a criminal offense that they are in that kind of a relationship with the government where the government has reason to know that the person is represented at the time that they go for their search warrant. In addition, in this particular case, the government had been asking for, through the production of grand jury subpoenas, information from that attorney, and they were getting responses from that attorney. So this isn't the sort of case where they needed to be secretive or they were unaware of whether the person was represented or not. They were in an ongoing relationship with Mr. Snyder's attorney. So under those conditions, they had very good reason to know that they would be collecting privileged information. And in continuing response, Judge Hamilton, to your question, there were also at the record 54, page 21 to 22, record 102, page 4 through 9, and record 106, 40 through 42, you will have briefings from Mr. Snyder's attorneys in which they argued the absence of time and content limitations and the overbreadth issue before the district court. So that that was fairly presented and pressed before the district court. The major problem, of course, with respect to this issue is the interference with the attorney-client relationship. And although, and this was the source of another error of the district court, because the district court dismissed this argument by saying that the attorney-client, the Sixth Amendment right doesn't attach to the time of indictment. However, the case law is clear that the issue of attorney-client privilege is key to effective assistance of counsel, and that when you interfere with the relationship between an attorney and a client, then you have interrupted that relationship upon which our entire system is founded.
And is it your view that that interference occurs regardless of government efforts to screen and prevent the prosecution team's access to privileged materials?
I don't take that broad a view. I do say in this particular case the government's procedures were insufficient. The government does argue...
But presumably then with sufficient procedures, this sort of thing can be done without violating Sixth Amendment rights, correct?
That's correct. If you look at the cases that have addressed this issue, basically two things are required. One is the court involvement prior to the turnover of the information to the prosecution team, and also notice to the court in some way, shape, or form that this is happening, and an opportunity for the person who has the privilege to review the documents to...
Why is that opportunity important in a criminal investigation?
It was particularly important in this investigation because the relationship between Mr. Snyder and his attorney was specifically in preparation for litigation. And the government knew that there would be, or had reason to know that there would be communications between the two.
Right, and they took steps, but I'm not convinced that at least in our case law, the court has to be involved, let alone that the subject of the investigation has to be involved in that process. The government why can't the government undertake that process at its own risk, in essence?
Well, that's what it did here, and it turned out badly. And
Well, there were 3 mistakes, right?
there
Arguably.
were. Well, we don't know the scope of the mistakes because there was never an opportunity in advance of this litigation for the attorney who was conducting the representation of Mr. Snyder to do that kind of privilege search. And in every case that I have read and cited in our brief, that has been a critical part of the process that happened. Either a magistrate judge was involved prior to turning over the information, or there was some review by the person who held the privilege that would allow litigation over the issue if there were a dispute between what was privileged or not. In this particular case, the way they conducted it, there was no opportunity in advance of the government's trial lawyers getting the material to make any kind of determination whether they should have had the material or not. And particularly,
Well, there was no opportunity outside the Department of Justice, right?
that's true. And another thing that was wrong with the way this was conducted and criticized in several of the cases that I've referred to in my brief is having a non-lawyer make the initial determination of how to search the documents. So in this case, we know that the Agent Field, who was the person responsible for doing that, admitted during the course of the hearing that he didn't know what work product was at the time that he suggested search terms to the people in Washington. And that left out a whole body of documentation or potential documents that were allowed to go to the prosecution without being reviewed at all. So that also was a problem in the context of this case, that you can't have a non-attorney making the decisions about how the information is going to be searched, particularly as he admitted in this particular case, there was no guidance to him from the government attorneys that were responsible for the case at the time.
I'm interested in where you were going with your answer to Judge Hamilton's question about the Sixth Amendment. You invoked ineffective assistance of counsel. Were you suggesting that even though, as the district judge ruled, the Sixth Amendment does not attach until the time of charging, that if there's an IAC element, we somehow can issue a ruling that kind of pushes that time back in time? Where were you going there?
It's not that it pushes. I would say that's arguing apples and oranges.
Okay.
The concern with an interference with attorney communications is that you're interfering with the integrity of the system, because the relationship between an attorney and a client depends on having the privilege, both privileged communications and the work product doctrine. And when you interfere with that, then you put into question the integrity of the representation. And you can't, as an attorney can't defend against what they don't know has occurred. So the government had access to attorney-client privileged communications at a time when it was investigating Mr. Snyder, and we can't know, and in part we can't know because the district court did not allow a hearing on this particular issue, how what they gained from this collection of privileged material and attorney-client communications affected their investigation, their interview of witnesses, their preparation for trial, their ability to respond to defenses that they had reason to know were coming because of the communications that they had access to. So there's a whole, the defendant can't know, and the court can't know all of the potential damage that is done when this communication is interfered with.
So we've got 3 levels of review outside the trial team, right? In the DOJ? we've got the Washington screening, then we've got a second tier, I've forgotten the details of that, and finally an AUSA
That's
as
correct.
the screening, right?
That's correct.
And as I understand it from the district court's work, we essentially have 3 documents that arguably slipped through all these sieves, right? Were privileged?
That's what the district court found. That's not what the defense team contended.
I understand that, but I don't, maybe I'm forgetting something, but have you identified any other documents that were privileged and slipped through?
Well, there were a number of documents that are identified or a number of sets of documents in which they found the email to be privileged, but not the attachments.
Right.
And-
So what I'm trying to get at, Ms. Gambino, is where's the harm here? Given the layers of screening and the results of it.
Well, the harm we can't properly identify, Judge, and the harm is in the I would say the ineffectiveness of the screening, and the fact that the people that were doing the screening were not even
It
aware.
sounds like what you want, you're criticizing the process, but it sounds like you want us to presume prejudicial harm that fatally poisoned the whole prosecution.
And that, yes, I am asking you to presume that. And in fact, I am along with the 3rd, 4th, 6th, and 11th circuits who find that prejudice is to be presumed in these kinds of cases. Now, and then with regard to presumed prejudice, the 3rd and the 10th in DC have adopted that position because it's the most protective. In the Levy case, for instance, they did point out what I've argued here, that it's not possible to know how the government used the information, the impact on the investigation, witness interviews, jury selection, and trial. And so this is not only the most protective standard for the defendant's Sixth Amendment rights, but also it's the most protective of the integrity of the system. And in Levy, the remedy was dismissal, finding that recusing the trial team who had access wouldn't cure the problem. And this is precisely the approach that was taken by the government in Wahi. They dismissed the case. Now, the government relies on SCARFO, which is actually not applicable to our case because it's a crime fraud exception. But even in SCARFO, the protections that were provided to the defendant and the holder of the privilege were far more extensive than were provided here. In basically each of the cases that has addressed this particular process have only approved it where you have some involvement with the court before the privileged material is turned over, or that you've allowed privilege review prior to the turnover of the material so that you don't have privileged material going to the government. And in this particular case, we have a couple of other concerns. In a very small office, like the office in Indiana, it's very hard to imagine that a Chinese wall is going to be very effective.
How big is big enough?
The most appropriate thing would be to have people who don't, at least a substantial body of people who don't know each other, or another office altogether. They had brought the Chicago office in for other reasons. They could have used somebody from that office. So
you're saying anytime, I guess the Chicago office you think is big enough?
I would argue that this is not a process that should be used without some neutral interposition by either a magistrate
do you
or...
think we ought to control that with case law?
Yes, I do. And I think there's case law that does make that clear.
Ms. Gambino, you're into your rebuttal time, but I was hoping you'd have a chance to address however quickly you want the other issue you mentioned, which was the statutory interpretation issue. If you choose that or some other issue and still want to reserve time.
Thank you, Judge. I would like to go to the statutory interpretation issue in this particular case. With respect to Mr. Snyder's case, it's our position that there was neither a bribe nor a gratuity demonstrated, and that the interpretation of what constitutes a bribe, a reward, or a gratuity is best laid out by the First Circuit in Fernandez and followed recently by the Fifth Circuit in Hamilton, where instead of interpreting a reward to be a gratuity under 666, it interprets reward to be another type of a timing issue with bribe, so that it modifies the bribe and when the bribe is paid rather than being a gratuity, because the penalties don't correspond. In 201, the penalties for bribery are the maximum penalties are 15 years and the gratuity are only 2 years. In 666, the maximum penalty for the statute is 10 years.
My biggest question there is, even assuming we adopt your position that 666 requires a quid pro quo showing,
Yes.
was there enough here for the jury to reasonably infer that? And I wonder if the blue brief draws the inferences in Mr. Snyder's favor, but that's not our standard of review.
Your Honor, it's our position that even if you draw the inferences in favor of the government, you can't get to a finding of a bribe or a gratuity without speculation. That the problem in Mr. Snyder's case is that there was no presentation with respect to either the alleged payor or Mr. Snyder and the corrupt intent. And that in order to get to that, you have to speculate about contents of phone calls, contents of meetings, and those were very few in and of themselves, as basically the Bujas denied that they had participated in any kind of bribery, and there was evidence that Mr. Snyder had been paid in return for work that he had done for them.
That's the work that nobody could remember?
Mm-hmm. Well, they didn't remember the entirety of it, but they did remember that he did consult with them with respect to insurance. They did remember that he provided an attorney meeting for them that saved them $30,000 in a particular tax issue that they were looking at. So, the argument wasn't that he did no work. The argument was that they didn't believe that his work was sufficient to be a consultant. But that is speculative also.
So, Ms. Gambino, I take it that it seems like the government's theory on the issue that Jackson and Kumi raised was that there is evidence that Mr. Snyder used Mr. Reeder to manipulate the bidding system by crafting a bid requirement or requirements that only one particular vendor could meet. That process went through, the contract was awarded. Shortly thereafter, there was a monetary transaction between the vendor and Mr. Snyder. Why wouldn't it be a reasonable inference that the monetary, that the money that Mr. Snyder received shortly after this contract was awarded based upon those facts was the product of a prior arrangement?
Well, it's the problem with that theory is that it wasn't supported by the evidence. In fact, there was more than one vendor that could have met the specifications, at least in part. There was no one specification that exempted or excluded.
In the first bid, there was the issue about the 150-day requirement, right? And there was evidence that was specifically that the particular vendor specifically had a conversation with Reeder that they could meet the 150 days. There was testimony from other vendors that generally in the industry 150 days was too short of a time, and that got into the bid requirements.
But they were not the That's true as far as it goes, but they were not the only vendor that was able to meet that 150-day requirement. The other vendor who was able to meet the 150-day requirement wasn't able to provide the kind of truck that the mechanics liked. And also the other source of that, or the primary source of that 150-day requirement, was Jeff Beck, who was impeached by Agent Field because Agent Field had interviewed him right away, and Mr. Beck had agreed that he told Mr. Reeder that 150 days was reasonable. And then Mr. Beck subsequently changed his testimony at trial. So there wasn't good evidence that this was bid rigging. This was a public process. There were other vendors who met the various qualifications, including the 150-day spec, but the Great Lakes Peterbilt happened to have the lowest bid and all of the specs that were required. So that isn't in sufficient evidence of bid rigging by any stretch of the imagination, particularly as there were alternative. It was also clear that this was something that Mr. Mayor Snyder had campaigned on, that he wanted to get done quickly, and he appointed somebody to do this, and there was no evidence that Mr. Snyder knew or had any input with respect to what the specifications were. There was evidence that Reeder talked to the mechanics, talked to his supervisor, talked to vendors, which you would expect someone to do in the course of putting something like this together. So, no, there wasn't sufficient evidence that a jury could infer wrongdoing unless it speculated about people's intent or facts that weren't in evidence.
We'll give you some additional.
Thank you, I appreciate it. We would ask Your Honors to vacate the conviction. Thank you.
Ms. Bonamici.
May it please the Court, Deborah Bonamici on behalf of the United States. Good morning. District Court correctly denied defendant's motion to dismiss the indictment or disqualify the trial team after finding correctly that the search warrant was not overbroad or deficient in any way, that the government did not intentionally invade the attorney-client relationship between the defendant and his counsel, that the government employed a legally and functionally adequate filter process.
There were problems here, which the district court acknowledged. And I wonder what would be the limiting principle if we were to approve the government's conduct in this case. What's to stop the government from employing this same process, without any other limits or protections in the future in a way that really can violate a defendant's rights?
Well, I think my understanding of the court's finding wasn't that there was a systemic problem with the process that was employed, but rather the court identified certain aspects of the implementation that resulted in, the disclosure of documents that shouldn't have been disclosed, albeit just a small number. With respect to a limiting principle, I think that the concept here is that it is important to, if you're implementing a filter process, it's important that that process have really all the qualities that this process had, which was that it be implemented by people who are walled off from the prosecution and investigation team, that it be done in a manner that is as best as possible capable of filtering out attorney-client privilege protection or protected documents. And also, I think, one aspect here that was weak was the concept of work product. And what we can learn from this case is that those terms, the search terms, we need to find ways to identify work product in communication such as these. And there are ways to do that. You learn from mistakes. But here, that just the general notion that's put forth in some of the cases relied upon by the defense and in some of the comments, early comments made by the district court, that there's almost a presumption that members of the filter team have a conflicting interest in advancing the prosecution or the investigation. That concept is not only inconsistent with the general presumption of regularity that actually attaches to the actions of the government absent a clear showing of misconduct, but also it really fails to take into account an important feature of this setting, which is that members of the filter team have a compelling interest to be as thorough as possible for the purpose of maintaining the integrity of the prosecution and the investigation. And I think what you see is that in most cases, that's evident by a conscientious and conservative approach. In fact, that conservative approach was described by the case agent in terms of the instructions given at the initiation of this process. And the very limited number of documents that slipped through in this case and the limited number of cases where problems occur. And so I think that whole concept that we need to be on guard because the fox is in the hen house is something that, it's an undercurrent that really isn't supported. It's certainly not supported by the evidence in this case, in which the district court expressly found that none of the actors in this case did anything untoward of any kind. None of them had any intent to breach the privilege that was at issue here. So in this case, it would seem to me that this filter system was appropriate and legally permissible. I do think that it is a true fact that as time goes on, the government, and as technology improves, and as we have more and more experience with collecting large amounts of ESI, the government, consistently works toward improving their systems, because the government's interest in these cases not only is to do justice generally, but in general, I mean, it is a huge waste of resources. I mean, even on the economic front, right? I mean, on the least important piece of it, even that is not useful for the government to ignore privilege. But that's not the primary problem or issue. But even when you get down to the end, it's never good for the government. It doesn't help the government to do this or to make mistakes. And it is, and I would say it is important, very important for the government to take these tasks seriously and to use the best practices in every case. And that's what is done. To alter things in the manner that the defendant has suggested, which we agree with Judge Hamilton's suggestion that there is no case support from the Supreme Court of the Seventh Circuit for a requirement that a neutral court or a neutral person, a court, a special master, or much less the counsel for the defense be involved at the initial stages of a privilege review in the context of an ongoing investigation. I mean, that is not supported at all by the law. Even the cases unlike the cases that the defendant features in their argument, this case does not involve subpoenas, does not involve a law office, does not involve a question of searching documents already determined to be privileged for documents falling within the crime fraud exception. It's none of those things. This case involves a search warrant issued to an individual who was known to be represented, that is an accurate fact, but who was the subject of an ongoing and broad-based investigation being conducted by the grand jury. And while we certainly agree that safeguarding the attorney-client privilege is an extremely important interest, there are other extremely important interests at issue in this context. And chief among them is preventing the interference with or delay of an ongoing grand jury investigation, which is, a well-settled piece of our law that is to be avoided whenever possible. And another aspect or another interest is judicial economy. The idea that the district court would be expected to get involved with with reviewing the results of a search warrant in every case involving anybody who is or may be represented by counsel. I mean, it's obviously impractical.
Well, what does the government do, Ms. Bonamici, if in carrying out a search warrant, for example, of a defendant's or a target's home, and looking, let's say, for evidence of drug trafficking, and the team is reviewing documents in the home and they turn up attorney-client communications? How's that handled?
The proper procedure in that situation, I believe, is to stop, don't read the document. As soon as you recognize that it's attorney-client, you don't look at it, and then to report the fact that you located it, where you ran into it, what you saw, and report that to if it's agents who are conducting the search, it's normally the case, report that to the prosecutor, so that it can be dealt with in an appropriate fashion. That is the normal way, and that would also be the way if we had not anticipated that there would be attorney-client communications in this particular search. That would be the same instruction. And Judge Lee, I agree that it's not true that the government can always anticipate that attorney-client privilege documents may be collected, but in this case they did anticipate it. They anticipated it, and they set up in advance the procedure that they wound up implementing with respect to all of the emails that were collected. So there are cases when it can be anticipated, but again, this is a very distinct situation from, for example, a law office where there may be multiple clients. There's likely to be, a great volume, a great percentage of privileged documents that are collected. Those circumstances, do call out for special procedures, and the Department of Justice has special procedures for those circumstances.
What about in situations where, to use Judge Hamilton's example, when you go to a person's home, the government knows that person's represented, and as part of the seizure, they seize the hard drive of a computer. In those situations, would a similar filter team typically be utilized, or would the government just simply go through it and rely upon Rule 41?
I'm not sure that there's a single answer to that question. I think that it is likely that the similar procedure. I mean, this search was conducted 5 years ago, and I'm sure that I know that in the Northern District of Illinois there have been adjustments to our protocols, and I assume that that's the case in Indiana as well. But it would depend, the particular question you asked, I think, would depend on the scope of the documents to be retrieved. It's a very unusual case. In fact, I've never seen one where a search warrant would authorize the search of an entire computer, right, hard drive. Maybe it would be a specific hard drive that we knew that certain information was being collected on, or you know what I mean, or there would be certain topics that we were searching for, and so there would be a question of whether attorney-client privileged materials would be likely to be in that subset of materials that were being searched for. And in that case, I think there would be, the kind of procedure that we have, that we see in this case, or something like it, an updated version of what we see in this case. So if there are no further questions on this point, I'll move to the statutory construction point. With respect to the defendant's arguments with respect to his conviction on a federal program bribery under 666, the defendant was properly convicted of that count. and the evidence was more than sufficient to meet or to establish his violation of that statute. And that is true whether or not you were to accept the defendant's construction of the statute, which we disagree with entirely, of course. In this case, the defendant, as was previously brought out, there was ample evidence presented to support the notion that the defendant had an advance agreement with the Buhas, and that the payment that was made after the delivery of the trucks was a function or the product of that prior arrangement. That's what the district court found when it reviewed all of the evidence and denied the Rule 29 motion, and that's what is clear from the record.
Ms. Bonamici, do you agree that the instructions given to in this trial would have permitted a conviction based on a gratuity theory?
Yes,
Okay.
I do.
Is that right? Okay. So that there's probably no way for us to duck then the choice between 666 covering both gratuities and bribery, or just bribery alone.
No, I think it works the opposite way. I think that the fact that the defendant clearly, the evidence was more than sufficient to establish that the defendant committed a bribery offense.
Well,
What you're saying is that
if I agree with you on that point, though, still the instructions allow either path. And I would think that if we were to disagree, if we were to change circuit law on the scope of 666, we would then have to order a third trial.
Well, what I would say, I mean, understanding the distinction between a count that's found to be inadequate legally or factually, I understand the point. But in this case, because the evidence pointed clearly to a bribe, because the language, because the whole case was tried as a bribe case, and the arguments focused completely on a bribe, I think that this is a case in which that standard would not necessarily be met. This is not, I would say that the jury's choice is not completely ambiguous in this case. And I don't actually think if a bribe or gratuity is allowed, then that would be a means rather than an element of the offense. And it's not entirely clear, it's not clear at all, that the jury would necessarily have to be unanimous with respect to the title or the label or the means by which the defendant committed the offense. So for that reason as well, I don't think it would necessarily require a third trial. You'd have to make it through a couple of gauntlets before you reach that point, is what I would say. This court has on numerous occasions found that contrary to defendant's argument and the cases upon which he relies, that 666 is distinct from Section 201 in a number of ways, including the fact that it treats bribes and gratuities together. The defendant's argument that the evidence was insufficient and unclear with respect to the lack of testimony from the bribe payors, I think actually is of interest to the statutory construction question as well, because the 666 makes very clear even by its structure alone, but also by its language, that the focus of the two separate sections, A2 and A1, I always get this wrong, ending in B, the bribe taker provision. The difference between those two things, or the separate treatment of those two types of crimes, demonstrates that the line is between that the statute creates is between the payor and the payee, and it's in the case of where the payee is prosecuted, it's his intent that's important. And a gratuity, the distinction that the defendant argues regarding rewards and gratuities often have to do with time frame. And as she points out, the argument for calling a reward a gratuity or not calling, or calling a reward not a gratuity but a separate or a different kind of a bribe relies on a difference without any meaning, because that in reality this type of corruption arises in all kinds of different fact patterns, and the question here is whether the conduct is corrupt, whether it meets the standard that is set forth in the statute. The statute's plain language says that it talks about accepting the payment as a bribe or reward, or to influence or reward. And influence is commonly understood as bribe, and that makes sense. And a reward is commonly understood as either being, if it's the product of an advance agreement, then it's also a bribe, it's just a later payment. And if it's not the product of an advance agreement, it's still corrupt. It's of the very same nature. And although we think that the plain language of the statute is more than sufficient to allow this court to maintain its course over, years and years, and not take this opportunity to change course, we did present in the brief some additional legislative history that suggests that this idea that we should be looking at Section 201 as somehow informing us as to whether they're, or not only informing us, but honestly, the way that argument reads, to my mind, is that the existence of 201 makes the plain language, influence and reward are not big words, right?
And I think you had that opening to present that legislative history, because you are right that our precedent is long on this subject, that the statute covers both bribery and gratuities, but I think the previous cases are short on statutory construction. Would you agree?
No. I think Bunder is a case that goes quite deeply into it. Statutory construction, if by what you mean by that is looking at legislative history and other forms rather than focusing on the language, I would say that the construction arguments in the previous cases are focused on the language of the statute primarily, if not exclusively, and do not travel off into the other courses, except that where, turning now to the cases relied upon by the defense, the existence of Section 202 is the primary basis by which those cases find the words influence or reward ambiguous. And ambiguity, of course, would be what would be required before you would turn to any kind of legislative history argument. And this court has held, and we agree, that those terms are not ambiguous. They say what they say, and there's no need to import different provisions of different statutes which appear different, are constructed differently, use different language. It just doesn't make any sense to do that, and it's not adequate to find the language of the statute ambiguous.
If I could turn for a moment to the obstruction of the IRS count. And the defendants appeal to the statute of limitations. I understand one of the government's arguments to be that Mr. Snyder misrepresented the assets that he had, or the control of companies, or the ownership of companies that he had when he was applying for approval for an installment payment, right? And I wanted to get from you what the government's theory is as to why the installment contracts would be a benefit to Mr. Snyder, since, as the defendant points out, he would pay the same amounts whether it was by installment or in one lump sum.
Well, the question is whether it's a benefit to him or whether it's a detriment to the government. I'm not sure, just want to make sure that I answer your question. Which are you focused on?
The former.
It's a benefit to him to postpone the payment. I mean, a loan is, any kind of loan is a benefit, right? I mean, it is of use to him. It is what he wanted. And it allowed him to continue living his, I mean, here's a factual way of responding to it. When he was subject to, when he owed the IRS approximately $40,000 in personal taxes and approximately $97,000 in payroll taxes, he transferred from his business to his personal account $110,000 in 1 year, in 2009. That's just an example because it continues all the way through this process. Now, $110,000 would have been enough to pay much of his IRS debt, and he could have done that. He chose not to. He used the money for other purposes. Having an installment payment plan gives you the opportunity to devote less of your current income to the payment of your debt, and takes it and allows you to pay it over time. I mean, that's the whole point of it. And the nature of the defendant's conduct with respect to his tax debt, I mean, it's elaborate, to say the least, but it was clear that everything that he did, for all the way down the line, everything that he did was not an effort to repay the debt as soon as possible or whenever he could, but rather to misrepresent to the IRS his actual ability to make payments or his ability to pay off the entire debt. Repeatedly, in various ways, going to the extent of opening up a bank account and setting up his business so that all the money flowed through another company they didn't know anything about. So, I mean, this clearly was, I mean, he went to an awful lot of effort if he didn't get anything for it, is another piece. That's what I'm trying to convey. So it is a benefit, and it is a misrepresentation, and we didn't have to show that it did impact the IRS's administration of the revenue laws, but of course it did. So the evidence was more than sufficient. And with respect to if the question at all deals with the specific statute of limitations, that's not the only thing that went into that, or that's not the only action he took within the statutory period. He was well into the statutory period, continuing to run his affairs through SRC. I mean, he was continuing to hide income. He was telling lies. He was doing other things. So it's not that the entire statute of limitations analysis revolves around that single corrupt act. There were multiple corrupt acts, and including those were the obvious ones because those went directly to his communications with the IRS. But the corrupt acts that he engaged in, that he either reported falsely or failed to report to the IRS, were also corrupt acts that were part and parcel of his corrupt endeavor. Does the court have any further questions? If not, then the government would request that the defendant's conviction and sentence be affirmed.
Ms. Gambino, we'll give you 7 minutes.
Thank you very much. Going back to Judge Hamilton's question with regard to whether if you reorganized or adopted the First Circuit's interpretation of the statute, you would have to send it back for retrial, and I would suggest that the answer is yes, because the gratuity issue, we know under current law, anything that increases or decreases the defendant's penalty is an element and not merely a modifier. So you would be correct, Judge, that if you interpret reward as gratuity, we don't know whether he was convicted for gratuity or he was convicted for bribe, and that would have to be clarified with the proper jury instruction. This court itself has recognized that there are three different categories: as separated bribe, reward, and gratuity, and the language simply isn't clear, particularly when you take it in context with 201. They are related. 666, as referred to in the legislative history, developed as a response to needing to prosecute state and local officials for bribery because it wasn't clear that 201 covered that.
Ms. Gambino, is it your position that there is no federal criminal restriction on state and local gratuities?
That's correct, Judge. Now, with respect to... So how fine is the line between a gratuity and a bribe? Well, it's pretty clear in Section 201, and the language is whether the money is offered for, because of, and not in return for. And
right, and there's no corruptly,
quid pro quo.
no corruptly adverb in
Right.
gratuity.
Right, and bribe is pretty clear that you need a quid pro quo, and that certainly wasn't demonstrated in this case. And while it's true that the government presented or argued initially a bribery case, in closing argument they kind of switched around and talked about reward and gratuity. So in this particular case especially, it would have been very helpful to the jury to have had a definition that separated bribe, reward, and gratuity. So it's our position that either way that you go with respect to 666, Mr. Snyder is entitled to a new trial. With respect to Judge Lee...
Wait a second. If we stick with our current precedent, I understand you say there's not sufficient evidence to support
That's
finding.
correct.
But that would, if that's the case, then there's a judgment of acquittal. Right?
That's correct.
Okay. But if we stick with our course and we think there is sufficient circumstantial evidence to infer either a gratuity or a bribe, then we should affirm.
Well, no, because then the jury wasn't properly instructed, because we don't know which way, what they depended on, as both were argued.
Did you ask for, okay, I guess I'm a little confused here. I thought the position at trial was 666 simply does not apply to gratuities.
That's correct.
I didn't think the position was you have to instruct the jury to choose between gratuity and bribe.
No, the position is that it doesn't apply.
Right. Right. I thought you were telling me a moment ago, though, that even if we stick with our course of applying 666 to both bribes and gratuities, we should order a new trial because the jury was not properly instructed to distinguish between the two theories. Maybe I misunderstood you.
I think I'm a little bit confused, Judge. Maybe I misspoke. But if you stay the course, he should still have been instructed. The jury, he should still have been instructed about the bribe, reward, gratuity distinction, because it was the defendant's theory that the statute doesn't cover gratuities.
Okay. All right. I don't want to distract you further. Thanks.
With respect to the obstruction of the IRS, Judge, I think that that it's correct that this was an installment payment and that he didn't benefit. In fact, he ended up paying more than he would have if he had paid it on time, because he managed to pay in full penalties and interest before this case was even indicted. And the problem with the government's case was that these 433A agreements that they relied on, the agent testified and admitted that the information they contended was missing wasn't in fact missing, that they were missing a page that referred to SRC in one of the 433As, and that in the other one there were boxes checked suggesting that there were other documents that were included which he didn't have, and he couldn't say whether the IRS had or didn't have, but the accountant did have. So the testimony from the agent showed that they didn't even know, or that agent didn't know, whether they did or didn't have all of the documents that they were relying on to claim that Mr. Snyder lied. So there wasn't sufficient evidence to support that, and there was no benefit to him in successfully completing this installment agreement, other than he met his obligations.
Thank you.
Thank you.
We thank both the parties in this case, and we have a special thanks to Ms. Gambino. I understand you were court appointed.
That's correct, Your Honor.
So you have the thanks of the court for your work. This concludes the arguments in Appeal Number 21-2986. We'll turn next to Appeal Number 22-1583, Nulogy Corporation versus Menasha Packaging Company, LLC, et al. And we'll have Mr. Lin when you are ready.
Thank you, Your Honors. This is Terrence Lynn of Gardner Lynn for appellant plaintiff Nulogy Corporation. This is an appeal from the Northern District of Illinois due to the improper dismissal for forum non-convenes based on a motion by two of the defendants, Menasha. There was also a motion brought by two of the defendants, Deloitte, for a 12b6 type of motion, which was denied or dismissed as moot. This is a trade secret case that relates to a Nulogy's computer directed tool that they call the Nulogy solution. It's a supply chain management tool that allows a company to track inventory and its production status, etc. Nulogy had licensed the Menasha companies for using the Nulogy solution at a limited number of facilities. That was installed and used and employed for a number of years by Menasha. In 2015, however, Menasha came up with a new project. It was not just an extension of the existing license. It's not a matter of saying, well, we want to use the Nulogy solution at some additional facilities. The new project that they referred to as Project Zephyr was Menasha and its workmate Deloitte were going to come up with a single system that would interface with and implement the Nulogy solution as well as other systems. And it was going to be an integrated operating platform. It was transformative, and it was not just a matter of we're going to use the Nulogy solution. It had to interface with it and interact. For this new project, Menasha issued a confidential request for information. They needed information as to how the Nulogy system was set up and how it functioned. It was different than, tell us how to use this Nulogy solution. You get that with a license. For this particular situation, they're coming up with something new, and they need to know intimate details about the flow patterns and the organization of this Nulogy solution. That's not information that would be given with a license.
Mr. Lynn,
Yes.
Obviously the merits are not before us. It's helpful to have a little background. Could you tell us, in essence, why the choice of forum is so important to you all here?
Yes, it's critically important in that Deloitte adamantly asserts that it is not subject to Canadian jurisdiction, and that if this case goes forward with it does not go forward, Deloitte will be outside of the case Menashe.
How do we know Deloitte is not subject to jurisdiction in Canada? Do we have anything other than their bare assertion? I mean, no court in Canada ruled on it. You all didn't wait.
That's correct. In fact, Nulogy was in a position that it couldn't wait. If the Nulogy were to and did accept Deloitte's assertion that they were not subject to jurisdiction in Canada and that the proper forum was in the United States, if they didn't do that and they instead contested it in Canada, by the time the resolution of that issue in Canada was finished, then the potential for statute of limitations would have run, and they could not have brought a trade secret action in the United States.
What about the prospect of a stay? What about simultaneously filing an action in the United States and asking the court here to stay the proceedings here while the issue of personal jurisdiction is hashed out in Canada?
We didn't do that, Your Honor. At the point in time that the motion was brought, they were just saying the court should get rid of the case in its entirety.
Well, look, there's no perfect solution to this problem, right?
No.
Okay, you got. It's a kind of an elegant problem in a way. You've got two defendants. Each has a very strong argument against one of the forums in question. Okay, so either you have to override one of those arguments or split the case up. And one option is you go forward in Canada against Menashe, and we remand Deloitte to the Northern District of Illinois for pursuit against them here, and maybe that gets stayed and maybe not.
That would be an option because it would preserve the ability to go after Deloitte for the trade secrets here in the United States. The concern, and a sincere concern, is that if the case is dismissed in its entirety as to Deloitte, they are out of it, home free, because we've got statute of limitations issues that would run. So that solution would at least address that problem. Now, this court's precedent is pretty solid that there has to be an available alternative forum for all defendants.
Now, you're relying on the Deb case, right?
That is correct.
And that did not involve a contractual forum.
That is true.
That seems to me a problem for you, because if you can override a contractual forum clause simply by adding another defendant who's not a party to the contract, then those clauses aren't going to be much good to anybody.
Well, they are, Your Honor, in that what was added was a company that was intimately involved in the activities dealing with the trade secrets. The trade secret claim is separate and distinct from the contract claim.
Well, as a matter of legal theory, yes. It still, frankly, seems to me to be a claim in connection with the agreement.
Well, the cases that have dealt with in connection with are ones in which there is some clause or clauses in the agreement that directly relate to the cause of action.
Well, okay.
We would argue that in connection with is more narrow.
I know the argument. I'll just tell you, I'm skeptical about it.
Your argument asks us to ignore your very complaint.
I'm sorry.
Your argument asks us to ignore your very complaint, which cites the license agreement.
Well, the license agreement is certainly background, and it reflects the
But it's more than background. It's the reason why Nulogy actually provided the information in the first place, right? Absent the license agreement, I presume Nulogy would not have provided the information to the defendants.
Yes, in part. I'll answer that directly here. The Nulogy computer program was provided, and they taught them how to use it as part of the license. That they would have done, but as a result of the license, they would not have told Menashe and Deloitte, this is how it works. Here's the organization and the operation and the functionality. That was something different in a different post Project Zephyr program. What the situation was is that because Menashe and Nulogy had a past relationship, Nulogy was in a position that they trusted them. Now, were they stupid to trust them? apparently, but they were prompted to provide additional information that's not necessary under the license to run this equipment. It was transformative as to the workflow and the way that the actual programs and solutions operate that they were trying to get and that they used. It's the computer in your office. You know how to turn it on and run it and make it do all the programs. But you don't have to know, well, what goes on inside of that box? How do you have that information organized inside the box? That's the difference. So yes, as a backdrop, Menasha never would have had their hands on the Nuology solution but for the license. But with just the license and the Nuology solution in hand, they wouldn't have been able to replicate it. Perhaps there'd been a way to tear it apart in some fashion, but that's not what they did. They went to Nuology and said, we've got a new project. It's going to be future agreement. You're going to have a whole new set of activities and agreements, and we will, tell us how your system works, and we'll interface with, when we come up with our new program, we'll be able to interface with the Nuology program, and now we'll have a new set of agreements, projects, opportunities, what have you. It is not just simply, here's the Nuology solution, here's how you turn it on, and this is how you operate it. When it comes to, and I cycle back to the availability, in this case, if Deloitte is released in its entirety, there has not been a statement of what Menasha will or won't argue necessarily in Canada. But as sure as I'm standing here, Menasha will say, if something happened, it was Deloitte's fault. And Deloitte's not here, and we didn't have anything to do with it. And that's what you're going to see if Deloitte is released from this operation.
And Mr. Lynn, even when, getting back to a point that Judge Hamilton raised, I take it that even when there is a contractual forum selection provision, the district court still has to engage in a forum nonconvenience analysis, although modified, right? I mean, there's some shifting of burdens. The district court doesn't have to look at private interests, but the district court still has to go through the various steps of a traditional forum nonconvenience analysis.
That's absolutely correct, Your Honor. And the way it works, and you could debate, which step do you do first? But one way or another, under the forum nonconvenience analysis, which is the doctrine you're using for implementing the forum selection clause, under the forum nonconvenience analysis, the first step is there an available and appropriate alternative forum? So you have to do that analysis.
Did the district court do that here with regard to Deloitte?
No. We contend the court did not. What we contend is that the court said, well, you voluntarily dismissed Deloitte up in Canada. Maybe you were stupid for doing that, but they represented to you. You did not take it to the bitter litigated end, and therefore we don't have to make a determination of whether or not there's an available alternative forum. So the analysis was short-circuited. Now, under the forum selection clause, there's another first step. You have to say, well, in this case, does the forum selection clause even apply to these causes of actions? And to Judge Hamilton's point, does this in connection with clause apply to these causes of actions? We briefed it, we say that it's different, and it does not. That said, whichever first step you start with, and we would contend that since the forum nonconvenes is the overarching implementation, you start there, you have to have both availability as to every defendant, pretty straightforward, and the forum nonconvenience clause has to apply. Your Honor, I'm happy to take other questions. Otherwise, I reserve my time.
Thank you, Mr. Lynn.
Thank you very much, Your Honors.
And Mr. Elkin?
May it please the court. Good morning, Your Honors. Michael Elkin on behalf of the Menasha appellees. After the district court properly found that the mandatory forum selection clause applied to the trade secret claims of Nulogy, it thereafter exercised its discretion to dismiss the case based on Form 9 convenience. We submit that that exercise of discretion was appropriate. What I would like to address is really the crux of Nulogy's appeal, which is whether you can enforce a forum selection clause where the plaintiff has added an additional party that is a non-signatory to the agreement that contains the forum selection clause. In that regard, Your Honors, the starting point is Atlantic Marine, where the U.S. Supreme Court held that when deciding a motion for Form 9 convenience, the forum clause should control except in the most unusual of cases. And we submit this is not the most unusual case where the forum selection clause should be disregarded. Under Atlantic Marine, the burden is on the plaintiff to show that the forum selection clause should be set aside. And the burden, the initial burden is not only even on the plaintiff under this court's decision last year in IAC Interactive, the court said that the first opportunity that the court has to adjudicate this issue has nothing to do with an alternative and available forum. It has to do with whether or not there is a mandatory forum selection clause and whether or not it applies to the claims. That's exactly what Judge Rowland did here. The Nulogy's central argument against dismissal is based on this notion that the Ontario court doesn't have jurisdiction over Deloitte. But that issue has never been tested.
So what? I mean, are they required to litigate that to the Supreme Court of Canada?
They are not, Your Honor. But
So what's the line? I'm pretty troubled by the dismissal of Deloitte here, and I'll ask Mr. Hardman about that. But
Sure, Your Honor. Well, first of all, what I would say, they're not required to do it, but by the very same token, they're asking, they asked the district court, and now this court, to determine that the forum selection clause should be disregarded. We were the ones, Menasha was the one that made the motion. The district court had the opportunity to exercise her discretion to dismiss the entire case. When she did so,
what? Okay.
When she did so, she did it pursuant to Atlantic Marine, a call to the court's attention, footnote 8, where the court said that when you have a Form 9 convenience, when the Form 9 convenience case deals with a mandatory forum selection clause, the appropriate measure is to dismiss the case. This court said that. It confirmed that in the Adams versus Raintree case, where the court said once it determined.
In Adams against Raintree, however, both defendants wanted to be in Mexico and were clearly subject to jurisdiction there.
That's correct, Your Honor.
Now we've got a situation where Deloitte and you are saying, well, maybe they are, maybe they aren't.
Well, Your Honor, that's what happened in Adams Raintree, if I may, is that the court said it doesn't really matter that Starwood wanted to litigate in Mexico. It said once there's a forum selection clause, the Form 9 convenience clicks in and requires a dismissal. And it doesn't really matter whether Starwood wanted to litigate there or not. I believe that counsel for Nulogy misspoke earlier when he said that both parties moved to dismiss on Form 9 convenience. It was just Menasha. But in that regard, the standard again is not whether or not this court believed that Judge Rowland exercised discretion in a way this court would have. She exercised her discretion. The issue is whether or not it was within the appropriate realm of conclusions that this court has stated in the past. And she was following Atlantic Marine. She was following
Counsel,
Adams.
if I might, yes, we look at her application of the relevant factors to the facts of this case on an abuse of discretion, giving her broad discretion. But we also looked de novo at whether or not she took the right steps. In other words, applied the right law. And is it your position that Judge Rowland did not have to assess whether or not Canada was an available forum, an adequate forum as to Deloitte?
Yeah, that's correct, Your Honor. Not only is there no requirement, the issue is whether or not there is, again, under this court's
So I take it
decision in IAC.
You disagree with the prior decisions where the court said that when you have a mandatory forum selection clause, that one of the first things a district court has to do is decide whether or not the alternative forum is available and adequate for all defendants.
Your Honor, that's not what the case law says. That's what the case law says with respect to where you don't have a forum selection clause. They refer to, and you all just discussed, this issue of Deb versus Cervera, where there's language that was picked up on by counsel in his brief related to that's the starting point. That is not the starting point when it comes to a forum selection clause. I call to your attention, Judge Lee, this court's decision in IAC Interactive that was decided in 2022, where the court said the beginning point is there a mandatory forum selection clause? And if there is, does it apply to the claims itself? That is the starting point.
Well, I'm looking at, you referred us to Atlantic Marine, and I'm looking at quotes from Atlantic Marine where the Supreme Court said, look, where there's a mandatory forum selection clause, the court does engage in a forum nonconvenience analysis, but that it's adjusted in three ways, right? First, the plaintiff's choice of forum has no weight. Second, the court does not have to consider arguments about the private interest. And third, that that there's a different burden when it comes to who has to prove what. But the court in Atlantic Marine basically said that otherwise the court has to use a forum nonconvenience analysis other than those three adjustments. Right. Well, our cases are replete that the first thing one has to do in a traditional forum nonconvenience analysis is decide whether or not the alternative proposed forum is adequate and available for all parties.
So let's assume for a moment, given Your Honor's question, that that's the standard, which I beg to disagree with regard to this court's decision as it relates to ISA Interactive. The test there is whether or not there's an available forum as it relates to the party who signed the forum nonconvenience, which is Menasha. And as it relates to Nulogy, I would just say the following, Judge Lee, if I may. There was a decision made by Nulogy to bring an action against Deloitte and Menasha in the Ontario Superior Court. There is a statement that was made with respect to jurisdiction where Nulogy claimed that the Ontario court had jurisdiction over Deloitte. They make a decision to do that, and even if you were to apply the alternative and available test, it applies with respect to Menasha, and we would argue, respectfully, that the plaintiff is precluded and is stopped from taking a contrary position with respect to Deloitte. And by the way, they've never made any statement at all that they believe that Ontario is in a proper form for Deloitte. They've never taken the position that the Ontario court doesn't have jurisdiction over them. They've been playing games, respectfully, and that's what this court has countenance against litigants doing.
Well, there's been game playing, but it's not just on one side. So we need to sort this out in some way that's fair to all the parties.
I would thank you, Judge Hamilton. I would just beg to disagree that all Menasha has been doing is to make an application to dismiss the case based on the forum non-selection clause that was in the agreement with the plaintiff. It agreed to litigate there. It has abided. Isn't
it kind of unusual? Usually the plaintiff wants to litigate at home, and the defendant wants to litigate at its home. Here the positions seem to be reversed.
Well, the irony is that this is not home for Menasha. Menasha is actually based in Wisconsin.
Exactly.
So but at the end of the day, Menasha is the party that is actually abiding by the agreement, and Nulogy is not.
Thank you, Mr. Elkin.
Thank you.
We'll hear now from Mr. Hartman.
I think I should address some of the court's questions, and I'd like to start with your question, Judge Jackson-Akawumi, and your question was, how do we know? And I want to make 3 points with respect to that question. The first is that we don't, because we don't until a Canadian court would actually decide it, or some other evidentiary battle takes place where it's resolved.
Is there any doubt that Deloitte is disputing jurisdiction over it in Canada?
My second point is that I want to be very clear that we, yes, are disputing jurisdiction over Deloitte in Canada.
Okay.
I want to be very clear about that. And my third point is that Nulogy is less clear with respect to its position on that point. We have made clear throughout that we don't believe we're subject to personal jurisdiction in Canada. They are far more opaque than that. Because if you look at the record in this case, they don't argue. They don't argue that there's no jurisdiction
Well, of course
over Deloitte
not.
in Canada.
They want to hedge their bets, understandably, so that they've got you in one form or the other, right?
That's right.
So, and you made no attempt to defend the district court's dismissal of you on forum nonconvenience grounds. Instead, you seem to want us to dismiss with prejudice, right?
Well, we do
On the-
say, we join the arguments of our co-counsel, and we
Okay.
do say,
Well, sorry. Let's take the merits here. You are arguing that you want dismissal with prejudice, correct?
yes, on the 12B6 counts,
Right.
I don't see how
Did
we
you
could-
file a cross appeal?
We did not file a cross.
So I don't see how we have jurisdiction to do that, or how it would even be ripe for us to adjudicate the adequacy of the pleading on the merits against Deloitte. If you want us to change a judgment from without prejudice to with prejudice, that takes a cross appeal.
Well, I believe that the court could affirm on alternative grounds on 12B6.
That's
the
what I'm
affirmance
pointing.
would be
That's what I'm
without-
asking you about, because you're asking us to change the judgment in your favor without having filed a cross appeal.
That would apply with a with prejudice ruling.
Correct.
I understand.
All right.
Can I address a couple of additional questions on forum nonconvenience, because we are an interested party with respect to that. Judge Hamilton, you asked why is it important that there's a forum selection clause, and Judge Lee answered that in the following sense. It is definitely true under Atlantic Marine that if you have a forum selection clause, you have to adjust the analysis. And a principal adjustment is that the burden shifts. And the burden shifts to the plaintiff to establish or to show that a transfer to the alternative forum is unwarranted. So the burden shifts. The burden is now on them. And Judge Lee, the burden shifts further. The adjustments are further in the sense that they have to do it based on public interest factors, not private interests of their own. And the court made clear that that is not going to happen very often. Okay? And the reason that's important in this case, Judge Hamilton, is that Nulogy has argued and has essentially taken a position throughout this case that it isn't their burden. They don't recognize it as their burden. And so they haven't affirmatively taken the burden of showing why transfer was unwarranted, not below and not here. And that's important because the district court was in a tough spot, but she had a record in front of her where it was their burden to show that transfer was unwarranted. And the record was they didn't even try to assume that burden. And so the record in front of her was they had sued us in Canada, so they have to believe that they can sue us in Canada, right? They didn't test that in Canada. Now, maybe they don't have to, but it is their burden to show that transfers unwarranted. They didn't submit any evidence that there was or that there wouldn't be jurisdiction over Deloitte in Canada. So, for example, in some cases, you have expert submissions or affidavits that say, here's what the foreign law is. They didn't do that. Maybe they didn't have to litigate it all the way to the finish line. They didn't, but maybe they didn't have to do that. But they had some burden to satisfy and to show that transfer wasn't unwarranted. And they didn't do that because they want to hedge their bets.
No,
Right.
everybody wants to
and-
hedge their bets. There's nothing wrong with that.
Absolutely.
But what's wrong, Mr. Hardman, with the approach of saying, okay, we enforce the clause for the benefit of the party who was the party to the contract, namely Menasha, but that doesn't apply to you all, and they can proceed against you in Chicago?
Because on this record, when this court is faced with the decision under Atlantic Marine to decide what to do, she has a decision to make. Nulogy can clearly go, and then she has to decide, Menasha, and then she has to decide what to do with respect to Deloitte. And here, on this record, where they didn't show that Deloitte couldn't be sued in Canada, which was their burden, it's not an abuse of discretion to say, okay, I'm going to dismiss the whole case. It's not an abuse of discretion.
So they have to fight you in Canada over jurisdiction in Canada.
I actually don't think it required.
That strikes me as a preposterous.
They could have
Of
submitted
course.
evidence that there would be no jurisdiction over
They have
us in
your
Canada.
assertions, right? You made that perfectly clear. There's no jurisdiction over us in Canada.
That is
Why can't they
certainly our
take you at
position.
at your word?
Because from the district court's point of view, our view doesn't control. The district court actually said that. She said, they sued us up there, they didn't test it, she has no other evidence to go by on that, and so she says that just begs the question. And it's their burden. So it's not an abuse to say, I'm going to dismiss Deloitte also. It's just not an abuse of discretion under the circumstances because the burden's on them. They didn't even assume the burden. let
How
alone
much would it
satisfy
take? Would they have to ask the trial court for a decision? Would they have to go to the provincial Supreme Court, to the Canadian Supreme Court? How much would it, at what point would it become an abuse of discretion to dismiss with respect to Deloitte?
Plainly, I don't know what it would have taken. If they tested it there and there was no jurisdiction, that would have been evidence plainly that the district court would have considered. If they had submitted an affidavit, that plainly would have been something for the court to consider. They argue now, where they didn't argue below statute of limitations. Footnote 8 of Atlantic Marine addresses statute of limitations explicitly and says that in cases where you have a forum selection clause, that's no longer a concern. That's no longer a concern. And so on this record,
Did Atlantic Marine involve defendants who were not parties to the contract?
it did not.
That does seem like a significant factor to me.
Well, the question then becomes, I agree with you, that's something to consider. The question really becomes, does that affect the burden shifting? And if you think about it, it shouldn't.
Well, if you think about it, it may, because Atlantic Marine precisely says there's burden shifting because we have parties here to a forum selection clause. In the case of Nulogy and Deloitte, we don't have parties to a forum selection clause.
Nothing in Atlantic Marine that I see says that the burden shifts back somehow to the defendant or defendants in the context of an additional defendant who's not
Well,
party
it's
to the
silent.
clause. I'm sorry?
It's silent.
I gather
No,
Deloitte has a lot of offices all over Canada, right? I understand we're talking
Deloitte-
about specific jurisdiction for at least American purposes.
I actually think Deloitte US likely would not.
Okay.
Deloitte Canada, the Canadian affiliate, likely would, but that's a different entity.
Okay.
Okay. Back to Atlantic Marine briefly, I realize I'm out of time. Nothing in it says it should shift back, and if you think about it, it shouldn't, because with respect to Menasha, it still has the forum selection clause, and it should still get the benefit of it. Putting the burden on the non-party to the clause defendant like Deloitte wouldn't make sense, because in some respects, we're a bystander. We're not even a party to the motion below to transfer. And so burden shifting to that party doesn't make sense, and I would argue that the burden shouldn't shift for those reasons. Therefore, at the end of the day, it was their burden to show that transfer wasn't warranted. And on the record before the district court, it may not have been a perfect situation, but on the record before the district court, the court did not abuse its discretion in essentially granting the motion to transfer, or the motion to dismiss on forum non-convenience grounds.
Okay, thank you, Mr. Hartman. Mr. Lynn, we'll give you your 5 minutes.
Thank you very much, Your Honor. Nulogy did not artificially reach out and put these people together. Menasha is the entity that brought Deloitte and Menasha together. The initial license, Menasha had the license, they implemented it, Deloitte was nowhere in sight. This Project Zephyr was a new project to develop something new, and Menasha brought Deloitte into the picture and said, make disclosures to Deloitte. And Deloitte said, yes, give them to us and we'll use the information for this purpose. And they used it for a different purpose. There's talk about burden shifting. Well, when we're talking about the forum non-convenes and a forum selection clause, yes, having a forum selection clause elevates that to a very important factor in the balance. And in some cases, it may be absolutely controlling. But the forum non-convenience analysis still must be performed, and step one is, do you have an available forum to all the parties? That wasn't done. That was the defendant's burden to establish this alternative forum. If there was an alternative forum, whether we had the burden or not, as to show the tipping of the balance, we put in information about the public interest factors. Whether that would have, should have carried the day or not, we can debate that till we're blue. In the Deb v. Silva case, there was no forum selection clause in that case. However, the ruling was, we don't know that jurisdiction is appropriate to the defendants in India in that case. They said, you have not consented to jurisdiction or said that it's appropriate. What the defendants had done is they were arguing that, well, we don't have an affiliation with some Indian company that would have given jurisdiction. So this court said, wait a minute, if you're arguing against any affiliation, you might not be explicitly arguing against jurisdiction, but inferentially you are. So therefore, you have to tell us whether you're contesting jurisdiction or not. And that's your burden to prove it. And that's what Deloitte's saying, that, well, we didn't have to prove anything. It was up to Nulogy to come in and then disprove the jurisdictional issue in Canada. Gamesmanship, Nulogy brought the action as specified in Canada against both defendants. Trade secrets were asserted there. Deloitte comes in and says, no, we're not subject to jurisdiction here. The proper forum is the United States. Silly Nulogy, they relied on that and changed it. It was, somehow it wasn't an effort to try and gerrymander Nulogy gerrymandering Deloitte in. They were there in the original action. That said, Project Zephyr was a different new thing post-license. If there's any other questions, happy to answer them. Otherwise, we'd request that the dismissal be reversed.
All right, thank you. We thank both the parties. The court will take a 5-minute recess before hearing case number 3. thank you, everyone. We turn now to the third case of the day. It's appeal number 22-2189, Meredith Dawson versus Great Lakes Educational Loan Services, Incorporated et al., and we welcome Mr. Harris.
Good morning, Your Honors. May it please the Court. I'm David Harris. I'm here on behalf of Meredith Dawson and the class of approximately 136,000 federal student loan borrowers, including the approximately 1,600 borrowers who were decertified at final judgment. I'd like to begin by just highlighting that it would be difficult, if not impossible, for me to distill 7 full years of litigation and all that occurred over 2 full rounds of complex class certification, 3 full rounds of complex summary judgment proceedings, including cross motions in the 3rd round. It would be hard for me to address all of that in the short time we have here today. We've addressed the issues that we believe are most material to this appeal in our papers, and I would just respectfully ask that to the extent I don't get to certain issues in the papers today, that the Court simply rely on our briefing in its entirety.
Mr. Harris, our time's a little short, so I wonder if I could just start with some questions.
Sure, absolutely.
So we have with regard to the damages and whether or not the defendants adequately mitigated all of plaintiff's damages. I understand that there are damages associated with the initial, what I will call, erroneous capitalization. And then there are these adjustments, right? There are 2 kind of adjustments that were made. One, as a result of the change request 2782, that resulted in the increase for some of the balances of some of the class members. And then the other one was a interest subsidy that had to be backed out, okay? With me so far? So aside, and I know that there was a lot of paper in the court below about whether or not the plaintiffs are entitled to, as damages, one of the adjustments that resulted in greater increase in their balance from 0 to some other balance, right? Due to the application of change request 2782. Putting that aside, putting those adjustments aside, does plaintiff believe, is your position that the remediation projects did remove or address the errors that came from the capitalization, the erroneous capitalization?
Thank you, Your Honor. So the answer to your question depends on how we frame the law. Before we talk about our view of the facts, we have to talk about what does it mean for the capitalization transaction to be removed from the account. And I think that's what Your Honor is asking. Is that correct?
Right, because originally, as I understand it, the defendants, I'll just refer to them as collectively as Great Lakes, right?
Sure.
As I understand it, originally they were thinking about just backing out the interest from the capitalizations, right? And then, and I'll talk to them about this, for some reason they decided they needed to rebuild the accounts. And the rebuilding triggered the 2 additional adjustments, right? And so if they had just backed out the interest from the erroneous capitalizations, would that have addressed all of the damages to the plaintiffs from the erroneous capitalization if they had gone that route?
If they had gone that route, the effect of that would have been to redress all of the damages, but I'd like to qualify that statement. The reason it would have addressed the damages is because that would have necessarily resulted in a financial benefit to the class members who were financially harmed at the time of this.
Right, because it would have put them back in the position, but for
exactly
the erroneous capitalization.
Right.
Right.
But however, even if that happened, we would still have this collateral source issue that we raised.
No, I understand that,
yeah.
but I'm just talking about the issue of the damages. So So then your argument is that because of this application of change request CR 2782, the balances of some class members increased, right? Like 16,000 or so.
Your Honor, that's actually not our position, but that's Great Lakes' position. And that position is actually not properly, it was not actually properly before the district court, and here's why. There was no legal argument ever made that this change request 2785 was actually what it was, had these requirements as a part of the loan. And there was no legal argument. The experts, Great Lakes brought 5 experts before the district court, and none of them opined that change request 2785 had these requirements in it. And even if they had done that, the district court held on its Daubert motion, on its Daubert order, which was docket 383 below. It said our expert couldn't opine on the meaning of the government's loan servicing requirements because that's a legal issue and it's a non-lawyer.
I guess what I'm trying to wrap my head around, and perhaps in a very kind of locutory way, is there are only a subset of class members that suffered from this increase in their balance, right? And if that's the case, and the class period is from 2006 to something like February of 2019, or at the latest, right? So if we're looking at trying to figure out damages, and we were remanding to the district court for damages, wouldn't that also open the question of whether or not there has to be additional subclasses, or whether or not the class definition needs to be modified to address those additional adjustments?
I would say no, Your Honor. Again, because that assertion that CR 2785 caused what actually happened with the debts is not before the court. It's a factual assertion. And that assertion was an assertion of opinion. So what happened factually, and it's undisputed.
But is that something that the plaintiffs contested in the district court, that the increases was a result of the application of CR 2782 when the accounts were rebuilt?
No, Your Honor, we didn't expressly contest it because we didn't feel we needed to legally. So I understand that Your Honor is trying to get at sort of the interplay between damages and these other adjustments that purportedly caused the debts to be whatever they are today. Our view of these other adjustments that came in the middle of the lawsuit contemporaneously with the purported backing off of the originally challenged transactions. Our position is that those have nothing to do with our theory of damages in the case. So our theory of damages in the case is that Great Lakes imposed these transactions historically between approximately 2010 going through 2015 to the point of filing the lawsuit. They were imposing these transactions on the accounts. So, these, can I use the demonstrative just briefly? It's nothing significant, really. It's just to give a picture.
Has the other side seen it?
No, but I can show it to them. They've seen something like it over and over again.
I would think that would be.
I was just going to show how it's organized.
Is this something in the record?
It is in the record, Your Honor. I can't tell you exactly where. It's not in our appendix, but it was early in the case. So what are the transactions at issue? What are they? So, 8 years ago, Ms. Dawson gave me this document, and it's her transaction history. It just shows her payments and her balances on different dates. And on this list of payments, eventually is the capitalization transaction that we challenged. Legally, what is this? What is this transaction that's provided in the history of the loan? Is that harm? Is that damage? And I would assert that the answer is no. I would assert that what this is legally, this transaction record, is it's a record of, it's circumstantial evidence of negligence. It's a
If
business.
it's not harmful, what are we doing here?
So it's a business record that shows that they were negligent historically, and so
Sorry.
So
What's the harm?
So the harm is what we lay out in our proposed findings of fact during summary judgment round 2, and it's at the short appendix, which is at page SA 407. And what the proposed findings of fact there show is that what Great Lakes reports to the government, what they report to lenders, what they report to credit bureaus, etc. I could go on, National Student Loan Database, you name it. They have a direct line to the federal government's general ledger, and what they report to the general ledger in real time on a daily basis is the total debt. It's the loan balance. At the moment this happens, this transaction happens historically, the loan balance doesn't actually increase. I still have the same debt the day that a capitalization transaction occurs. My injury is not by the type of interest that accrues. It's not by the way the debt is calculated. Great Lakes could negligently calculate the debt in a way that helps me. And in fact, that's what they say they did with these other adjustments. They're saying historically, we were...
Mr. Harris, I'm waiting in suspense for you to answer what it is. What is the harm?
The harm is the increase in my debt. It's the federal government having on its general ledger a larger number than it would otherwise have, but for the way that that was calculated.
Okay, and the defense has come forward with, in particular, Mr. Bankhead and his team's study for the effects of the remediation projects, and with the different categories of borrowers. What do you have that actually disputes their conclusions about the sufficiency of the remediation projects?
So factually disputed, we have deposition testimony from one of the experts, and I don't have the docket number in my head, but you may recall the order of the court shortly before the third round of summary judgment, where Judge Peterson said, look, I see that they have these expert reports now. How do you plan to address these at trial?
Right.
And we
You say that's unfair, but I understand why the district judge would insist on that. And I'm trying to ask you the same question today.
Sure. And so in response to that order, we set out briefly in like a 4-page argument that we had deposition testimony from one of the experts showing that he conceded that on some of the accounts he reviewed, the transactions were still there. And so my co-counsel deposed him and said, hey, so if you extrapolate this out from your statistical sample...
Was that before Bankhead's final report? Because there were some exceptions, correct?
The deposition occurred between the time of the initial report and the quote-unquote supplemental report.
Right.
Yes.
Okay. So dispute the supplemental report.
We haven't done that, Your Honor.
Okay, thanks.
Factually. We would say legally it's inconsequential. And the reason is these 3 expert reports collectively only purport to show one thing, that the transactions are no longer part of the debt calculation. They do not purport to show that the plaintiffs are in as good of a financial position as they would have been in had the transactions not been imposed for many years. And so what the law requires very clearly is that the plaintiff be put in as good of a position as they would have been in had the negligence not occurred. And Great Lakes comes in and says, okay, well, we haven't done that. We haven't put them in as good of a financial position as they would have been in had the negligence not occurred. But the reason is we had to make these other adjustments. Sorry, we don't have to show that they're correct. We're just asserting that you owe more money for other reasons, and we're going to call you net undamaged from the conduct alleged in this case based on our essentially counter allegations against you that were never pleaded.
But there's no factual dispute about those. You're saying they're irrelevant, I understand that.
No factual dispute about the other adjustments?
Yes.
The only factual dispute would be as to admissibility of the assertion that they exist.
And so I'm just really curious, when you said earlier to Judge Lee that the increase has nothing to do with your theory of damages. So then, in effect, you don't care about this extra $6.6 million that has now been introduced into the case.
So I may have misheard, Your Honor, but what I thought I just heard was that the damages have nothing to do with.
Judge Lee was asking about the increases to some of the borrowers' accounts because of the other adjustments that Great Lakes alleges it had to make because of change regulations of the Education Department.
Right.
You responded, this has nothing to do, that whole thing has nothing to do with our theory of damages.
Right.
So my question is, do you actually care about this extra $6.6 million that is apparently the result of that?
And the short answer is no. However, we would still maintain that we're entitled to the debt increases that we suffered as a result of the negligence. Because our debt was increased, because we overpaid, Elizabeth Mosser is the perfect example. She admittedly overpaid her debt in 2016, 2017. No dispute. And she didn't get a check. No dispute.
The defense says that she got credits to other debts or other accounts, right?
That was Angela Monger, Your Honor. That was.
I thought the defense said Great Lakes paid people like her the extra money she ended up owing out of their own reserves after they found that situation out. And are you contending there's just no proof of that?
So what they allege is that they concede that she overpaid before they remediated, okay? They concede that her debt was too high at that time that she overpaid. Then they remediated, and they add all this other stuff in, the debt goes up. We raised heck about that because they had told the court that people like her got checks. And their response was, well, don't worry about the delinquency, we're covering it. None of that has to do with whether she was ever remedied for the original harm. And the same logic applies to people who are still indebted. This court's case in Bible made very clear that compensable damages include the increase in the total amount owed. If I have an increase in the total amount I owe on my student debt as a result of negligence, I'm entitled to, according to Bible, cash or account credit. What did this court mean when it said account credit? Did it mean recalculate the debt without the challenged negligence, or in that case, breach of contract, but then increase it for some other reason that is just highly speculative, never litigated, never pleaded? Or does it mean the plaintiff was entitled to a personal financial benefit? Meaning, I'm here today financially. I'm only here today financially because they harmed me with their illegal conduct. Therefore, I'm entitled to be brought back down here at my debt level.
So I guess I'm just trying to understand. So the plaintiffs, what you want is, with regard to the $6.6 million, is you want that, to the extent those are additional obligations, you want those erased.
That is, if we concede that the remediation provided a $22 million actual benefit to the class, our view of that, and we don't concede that because Great Lakes came and said, actually, we didn't record the loan balance changes at all. But let's just say in an imaginary world where we conceded that issue, our view of that $6 million would be it's the shortfall between what we were entitled to as damages and what they gave us. I don't care why there was a shortfall. You can tell me it's CR 2785. You can tell me I took out another loan that I never took out. You can tell me whatever you want. And if you don't have to prove it's correct, then I'm still out $6 million for no reason.
Thank you, Mr. Hurst.
Thank you.
All right, we have Mr. Schreiner.
Yes, Your Honor. Good morning. May it please the court, let me get right to what Judge Hamilton properly took us to, which is damages. By the way, the claims of negligence have never been adjudicated. Negligence has been contested. And that's what a couple of the experts who we didn't get to talked about. So the question here is damages. Our defense, if you want to look at that, is sort of a defense of payment. It's a defense that we've fully remediated any harm, even if we were negligent in doing so. 2785, Your Honor, is the one that Mr. Harris interprets to say a different thing than we interpreted to say. But as a student loan servicer, we did what the Department of Education told us to do. Ultimately, after several rounds of what do you want, they said, we want you to go back on the back-to-back forbearances and remove the capitalizations that you put on there and associated interest from those capitalizations. This is years after the event. You're quite right, Judge Lee. Originally, we said, well, let's just take them out. And if that had happened, we wouldn't have had the consequences of future protocol changes in the department. The department said, no, we don't want you to do that. Actually, what they said is, you could do that if you want to, but it would take us 18 months to approve it, and we wanted to get on with it. So we did what the department told us to do, which was to go back to the time of the capitalizations, remove them, remove the interest, and then run the thing forward, run the accounts forward with the proper amounts of capitalization, with the proper amounts owed.
And Mr. Schreiner, when the department told you that,
Right.
that is, when CR 2782 and later on the department's authorization to Great Lakes to implement change request 2782, when that took place, had all of the erroneous capitalizations that are at issue, had those stopped, or
Yes.
were those still ongoing?
Yes, they had. They had because, again, we did what the department told us to. They said, going forward, don't do this anymore this way. Do it this way. So we did. So let me just turn to the question of the ground on which the district court ruled in our favor.
Well, if I could just put
Yeah.
a pin on that. So,
Yes, sir.
So CR 2782 was issued in September of 2014.
Yes.
DOE authorized Great Lakes to implement it in November of 2015. So by that time, this was after all of the alleged erroneous capitalizations had taken place.
That's right.
Okay.
Okay. Now, this is a case with respect to damages. Our defense has remediated the accounts. We removed the capitalizations and all the interest attributable to them. And that was proved, and this is just, you can read Judge Peterson's opinion. He understood it. This was proved by testimony and affidavits of competent employees, witnesses of Great Lakes on what the methodology was of how they did it, and that the protocols of the department and the student loan servicer business were followed. That is, they removed the caps and interest on all the accounts they were still servicing. Done. That's the great majority of the accounts. Through the department, they also, and this is in evidence, they also notified the new servicers, to whom sometimes these things are transferred, that's just part of the business of student loans, of the remediated balances with instruction to bring those into conformity. And there are several forms of communicating such information, and the usual ways were followed. That's what the evidence was. With respect to loans that had been repaid already, and there were some, told the Department of Treasury to send what we call the PIFT, paid in full overpayers, a check. Again, that's the usual way this is done. This isn't something that was never happened before. And Deloitte, by the way, confirmed that the Treasury did on the accounts that it looked at, the 1,800 in the sample. Great Lakes itself paid any overpayers on its own that it discovered later on, whose increases came from either lots of different things, Your Honor. It was the subsidy that they were no longer qualified for. It also, Great Lakes always had a policy of not capitalizing if the amount of the capitalization was less than $15. The Department of Education said, nope, can't do that going forward. And so there were some of those involved in there. But either by check or by credit to another account. And of course, that check, first of all, the Treasury education regulations require us to not send a check when there's another account with an outstanding balance. We credited it. That's all established on the record.
Mr. Schreiner, can I ask you a quick question? I'm glad you mentioned the defense of payment, because with all the swirling in the briefs. I'd been trying to follow this, and I had reached towards the affirmative defense of payment in the form of your remediation plans. So just procedurally, so that I understand this, would you agree what we've got is an affirmative defense of payment, and then in essence a motion for summary judgment saying we've proved it, and plaintiffs are arguing that what you've said is legally insufficient, legally irrelevant, but we're not factually disputing it.
Right. I think that's what we have. I mean, that's a way of looking at it. You know, we litigated this whole case on the original 2015 complaint, even though it asserted a violation that was corrected immediately. That was a computer error. The plaintiff never amended the complaint. We supplemented our answer at one point in the case. And it has always been our position that we were told to fix it and we fixed it. And Judge Peterson appropriately found that we did.
But we get to this, to me, the more interesting question that, you know, the district court is struggling with at the end, which is this $6.6 million. And, you know, this public policy, the public policy factors and weighing and trying to figure out which way that goes. And how do the public policy factors weigh in favor of not finding you responsible for that additional sum?
Let me start, first of all, by reminding the court of what my friend did when this issue came up earlier in the case about the protocols and the results of the protocols. I think we're assuming the 6.6 was largely the result of following the protocols. It said, because we said, well, they still had not had a damages class certified. We were still opposing the damages class certification, and we raised a 23B3 predominance argument, sort of like Comcast, right? And my friend assured the court on behalf of the plaintiff class that these new department-mandated servicing protocols had nothing to do with the merits claim or defenses in this action, as they were beyond the scope of this action. And then relying on those assurances, the court granted certification of damages issues, explaining that with that concession, with that bargain that he struck with the court, individualized issues would not predominate because Great Lakes would not need to justify all the other department-mandated adjustments that it made in the course of the mediation. Now, that is enough, it seems to me, the concession that he said that's not in the case. It's not in this case. But to get to your question, Judge Jackson-Acumi, about public policy, basically our public policy tort law, we didn't follow Paul's graph, we followed the dissent, so doctrinally we don't have a doctrine of that is followed in most states, but we've come to the same thing through these public policy state law, and this is a state law claim, public policy points, which are, and again, laid out in Judge Peterson's opinion. You don't, a legal cause, that's what we call it in Wisconsin. It has to be a legal cause. And the legal cause excludes things that are attenuated, that are far removed, that it would be unfair to stick on the alleged tortfeasor. And he went through and explained why those applied in this case. We didn't know at the time we allegedly committed our tort of improperly capitalizing interest that the Department of Education was going to require us to do it in this way, incurring those things.
But that's why I asked about the timing, right?
Yeah.
Because, I noticed that the class period is 2006 through 2019, right?
Well,
and
through some time. I'm not sure when it's
right.
over, but starting early.
And yet what you're saying is that these improper capitalizations ceased prior to November of 2015.
Absolutely.
Okay. And so why was the class extended beyond the time that the capitalizations
I don't know
took
that
place?
it would extend. I thought it was pleaded until the time of trial. I don't remember what the original pleading of the class period was, but simply because the case was still going, I guess. But there is no evidence, none whatsoever, that these so-called improper capitalizations, which, by the way, we still think we were doing things the right way at the day. Another aspect that would be interesting if this case had ever gone to trial was how did the plaintiff going to prove the standard of care of a student loan servicer responding to the Department of Education's instructions. We had a couple of experts on liability who said what they did was perfectly proper, was perfectly reasonable under the circumstances. Nothing on the other side about that. So this is a case that I think for a long time has been headed for where it ended up. And Judge Hamilton, you're exactly right. Judge Peterson's an experienced district judge. He wanted to know, what's this trial going to be like? They've got expert witnesses. You don't have anybody. What are we going to bring the jury in here and tell them to do with respect to damages? And my friend, he had opportunities to take further discovery, to take further depositions. He didn't. He just basically said, I'm done, and I've got legal arguments now, and it's A minus B equals C. I mean, no, that isn't a proof of damages. And in fact, the full remediation that was accomplished here, established in the record, took care of everything that is a consequence of the alleged negligence with respect to capitalizations of interest.
Mr. Schreiner, going back to a question that Judge Hamilton asked you with regard to the repayment, what evidence do your clients have that the checks were actually issued or the credits actually made? In other words, I know that you requested that DOD do certain things and you requested that your successor and interest servicers do certain things, didn't plaintiff present some evidence that some of the class members didn't get the refunds that they were entitled to?
He's got two, in addition to his client. And his client, by the way, is fully explained.
I'm sorry, can you answer the first one and then the second?
Yeah. Well, the evidence is that, first of all, in the supplemental report of Mr. Bankhead, he looked at those accounts and said that he found proof that it was done. Judge Peterson indulged a common presumption, and I think he may have even used this comparison. You put a letter in the mail, you presume it was delivered. We use that all the time in the law. We followed the usual protocols for what we do when we need to have the government issue, the Treasury issue a check, when we have a successor servicer know that we've adjusted the balances on the account that they took over. That's the proof. It's good, solid evidence.
I thought Bankhead went further than that, though, and they had access to Treasury databases and communicated with the other servicers and confirmed that, at least for their sample, they were in fact issued, and his exceptions that he had initially found were resolved.
Right, exactly. So to me, there's no evidence. That's what Judge Peterson said. What's your evidence against the defendant's evidence? And the answer is pretty much what you heard here today. Nothing. So I think that's basically what I have to say. A lot of other things I could say, but
could I ask you, Mr. Schreiner, briefly? There were some points made in the reply brief that I don't know that you've had an opportunity to address yet. One was the spoliation argument.
Yeah. When a spoliation. First of all, never raised in the district court. I don't know what that, I really don't know what he's talking about. He's suggesting that somehow, and again, it gets back to this concession he made to Judge Peterson, and he said it in just these terms, that the defendants are not liable for explaining all of the other matters, the consequences of the department's protocols. He wants us, again, violating the whole 23B3 thing, to be able to go through each account and say what happened in each account and give a balance on a given day. That defeats the whole purpose of litigating damages on a class basis.
The reply brief also brought up Ms. Mosser's situation.
Ms. Mosser says she didn't get the check. We think she got the check. We think the evidence shows that she did get the check. She apparently told him she didn't. I don't know.
Okay.
And Ms. Monger is the one who had the account balance adjusted on the other account. So I have to say, it's been a long time since I've heard a lawyer suggest that the district court was stacking the deck against the defendants and self-manufacturing a merits outcome for us. I will only tell you I think that's unworthy. There's no evidence of that. That's his view, and when you lose cases, sometimes you imagine all sorts of things. But that's an amazing position to be taking, and I want to dissociate myself from anything along those lines here. It's just, again, there's no proof. Thank you, Your Honors.
Thank you, Mr. Schreiner. Mr. Harris, we'll give you your 3 minutes.
Thank you, Your Honor. One thing I'd like to supplement, I guess, with oral argument today is the court is obviously focused on, to some degree, this question of how the facts, as they appear, line up with the elements or the affirmative defense of payment. You know, how do we map this set of facts as they evolved over time to what the law is? And, you know, so that kind of goes to our argument about the confusion of the elements, the element of breaching a duty, the element of causing harm in the first place, and then the separate issue, the affirmative defense, or the affirmative defense of payment, or the legal doctrine of a remedy. What is a remedy for harm? Apart from those issues, let's say this court decides there was admissible, genuinely undisputed evidence of a legally sufficient remedy mid-litigation for the harm that was caused. We still have this collateral source issue, and Great Lakes' main point on that is...
Your point is that Great Lakes doesn't get credit if refunds were issued by Treasury or by other servicers?
Yes, Your Honor. That's our position. And
that's astonishing. No. Okay.
So if we look at docket numbers one...
Could I ask you to address Mr. Schreiner's point about the concession made to obtain class certification?
Yeah,
that the various other adjustments were not part of the case?
Sure, and I would ask the court to go back and look at our brief that the district court responded to in its order, because my position, respectfully, is that the district court switched what we were arguing to make a different point than what we were making in our brief.
How so?
So our point was that Great Lakes cannot use other adjustments to offset their liability for the damages we had proven. And the district court took that argument and said, well, what they're really trying to do is recover damages for those other things. Our position is no, that's not what we're trying to do legally. They are trying to use other adjustments as an offset to damages.
No, the question for class certification is about individual issues predominating, correct?
Yes, Your Honor.
Okay.
And the district court recognized in that vein that there's no precedent for declining to certify a class because a defendant essentially does individual things in response to a case.
Right.
Because any class could be defeated by a defendant using a random number generator to redress the harm. And that's essentially what happened here, is our position.
Random number generation?
Yes, Your Honor. We believe that what actually happened here, was not good faith efforts at compliance with other adjustments that were never litigated. We
And
believe
the
that what
evidence
actually...
of that?
What?
The evidence of that, along with your evidence of bias in the district court?
Sure. So, Your Honor, we would say that the evidence shows that there may have been technical errors in the remediation.
What evidence shows that?
And so that would be the second 30B6 deposition of Great Lakes, which was at docket 227 below. And we touched on some of that testimony in our brief, where what they had testified was all we did was back off the wrongful transactions. We did nothing else. But then I have Mosser coming to me saying, I was paid in full and now I'm in delinquency. So I knew that Great Lakes' testimony was impossible. I knew it was impossible that all they had done was reduce the debts by removing the capitalizations. And so I deposed Great Lakes and I asked them, like, hey, is it possible that when you rebuilt these accounts on your very complicated database, that the system applied new and different algorithms than what had been used to calculate the debt risk historically? And she's like, yeah, I guess that could have happened. There wasn't some deliberation of, oh, now we need to comply with CR 2785, so now we're going to go in and do some separate procedure. The government at docket 165, it's undisputed, that's a declaration from Great Lakes. The government gave Great Lakes a choice on how to remediate. The government said, you can do an account credit, a straight debt reduction, formula-based. We'll have to review it, but we're not opposed to that. Great Lakes said, well, we don't want to wait, so can we just do this account rebuilding thing instead, where it's not necessarily an account credit, it's a total technological makeover of the debt. And the government said, yeah, go ahead and do that. That's totally outside the scope of this case. Great Lakes alone made the decision of how to provide a remedy, and the route that they chose led to very bad financial results from the class. They could have chosen a legally sufficient remedy, which would have been a straight account credit, formula-based debt reduction.
All right, well, thank you, Mr. Harris.
Thank you.
We will now move to case number 4, Martin Jaranowski versus Indiana Harbor Belt Railroad Company. That's appeal number 22-2437. And we'll hear from Mr. Burgess. I apologize if I mispronounced that, when you're ready.
May it please the court, counsel. My name's George Burgess. I represent injured railroad employees, and this is a Federal Employers Liability Act case. Just a little history, railroad employees don't get workers' comp, state workers' comp benefits, so the way they get compensation for work-related injuries is through the FELA. Okay. The FELA was passed in 1907 because, and this is from McBride, which is a United States Supreme Court case that affirmed the Seventh Circuit issue on causation recently, 10,000 railroad employees were killed the year before the FELA was passed, and over 300,000 were hurt, and this was on an annual basis. So the issues that we're here dealing with, these safety issues, are really very important, both for railroad employees and for the public at large. After the passage of the FLAs, those numbers came way down, and the FLA has worked to make railroads much safer for the employees and for the public. It's still a dangerous job. Marty Jaranowski, 53 years old, worked at the railroad for over 20 years. He works not as a conductor like on the metro trains, but works in freight yards. So he's climbing up and down the side of cars, riding on the side of cars, setting handbrakes, throwing switches. In the railroad industry, what they say is that inches mean the difference between life and death. It's a very dangerous job. One of the most important things is the taking care of switches, because switches, as Mr. Blackwell said, are a primary contributor to employee injuries and also a primary contributor to derailments, the car's derailment, when the railroad doesn't properly inspect and maintain their switches. So the regulations that we're dealing with are very important. It's and we're here because the magistrate judge gave summary judgment to the railroad, so there are some important factual issues here. What happened is Mr. Jaranowski's injury was depicted on video, and I've attached the video both in the district court and here that shows him operating the switch malfunctions, and he goes down until his engineer comes and calls the ambulance for him. The railroad goes out and does some inspection right afterwards, and it's really, the best evidence that we have, or some of the best evidence we have, that they knew or should have known of these regulatory violations in this MA27 switch. There's a federal regulation, the Federal Track Safety Standards, about vegetation. And as Marty Jaranowski said at his deposition, there's 2 trees growing in the ballast between the switch points.
So, Mr. Burgess, I've been struggling to try to understand what you think the defect is, because we've got, as I understand it, evidence about missing cotter pins and extra movement, the lost movement of the switch handle. Is the vegetation, how is the vegetation relevant?
So,
in particular, as I understand it, the force needed to operate this switch, when the railroad checked it right after Mr. Janikowski's injury, went as high as 126 pounds, right?
Yes, sir.
And then they did some lubrication and things are back within normal scope. That doesn't sound like a vegetation problem.
So, and it's, the court in the Steele case went into that in extensively, and Mr. Blackwell's report, which I know is real long, went into that extensively. What the ballast is the rocks that they use to support the track structure, and the ballast is supposed to drain water, and in this case, the ballast was fouled with dirt and other organic material to the extent that it was full of dirt and it was not draining water, which lets the vegetation grow. And so when you don't have the ballast properly supporting the track, that can contribute, as Mr. Blackwell explained, to the switch points binding up.
And just as a factual matter, by the time they lubricate, the railroad had already cleaned up the tracks, right? That was that 3-man, 40-minute cleanup. Am I correct about that?
No, that was a year later, Judge. So what happened is we got the case, we filed it, we did a request to go out there and inspect the switch with my expert, Mr. Blackwell. And the day before Mr. Blackwell was out there, and this is just because we subpoenaed the videotape, we never would have known this, but the railroad, in anticipation of my expert going out to document the deficiencies in the switch, had a 3-man crew work on that switch for 40 minutes, clean all the vegetation out, clean the ballast out, and lubricate the thing to the extent that there was grease oozing out of the switch stand after they had done. So that cleanup was done in anticipation of my expert going out there to look at the switch. And I mean, it skewed the fact record in this, except to the extent that when Mr. Blackwell went out there and did his inspection, there still were missing cotter pins that caused loose pins. The points were still skewed, and it still had excessive loss motion. So I did the math, and what they're moving, those switch points are 16.5 feet long, and they weigh 136 pounds per 3 feet of rail. So if my math is right, that's about 1,496 pounds of rail that Mr. Jaranowski is moving. And the reason that he can move it is because it acts as a lever. The points move a couple inches, and the switch handle with some gears inside is going to move a few feet. So, but it still took, when the railroad went out there and inspected it, way beyond the safe lifting requirements. It was 126 pounds. But when Blackwell went out there, he saw that you pick up the switch handle, and the points weren't moving. So what that does is, and that's consistent with Mr. Ritter's inspection, where it went from.
You're talking about what happened, your inspection a year after the accident.
Yes, but they're consistent.
Okay. Could I ask you a couple of quick questions more, Mr. Burgess? You tell us in page 40 of your brief that Blackwell says the conditions of the switch as depicted in the day of the accident photographs are not consistent with competent switch inspections. I didn't see that in the cited source. Could you help me out on that?
It's in his opinion on the very last page of his original report. Do you want me to grab it?
Last page.
I could grab it if.
Please. I was looking at the cited page 6 and around there.
Okay. So it's actually Appendix 18, and it'd be paragraph 14. Blackwell's opinions are set forth in his report and include: they failed to maintain it so it's operable, failed to control and remove dirt.
Sorry, I'm looking at what you cited in your brief. You want me to look at something else?
I'm sorry, I may have had a miscite. Yes, appendix on my brief.
Okay.
A18. And paragraph
Pages
14.
17 to 18. Okay. So that you want to cite pages 17 to 18 of that document?
Yes,
Okay.
Your Honor.
All right, thank you.
Sorry.
We don't know the case as well as you do. Also, so the defense emphasizes that the plaintiff himself operated the same switch 4 days earlier. If it was defective, how could he have missed that? Your response?
Yeah, so this is what they call a non-repeatable defect. It just depends upon whether the points are moving properly as he operates it. And sometimes when you catch the switch handle just right, the points will move properly. But clearly, when even when Mr. Ritter went out there, the IHB engineer, and inspected it right after Jaranowski was hurt, it wasn't operating properly on that day at that time he was hurt. And Mr. Blackwell attributes the failure to operate properly was that 11 days prior, the railroad, when they ostensibly did their inspection, didn't see the problems with the ballast that were obvious. They didn't see the problems with the missing and loose bolts, missing cotter pins, and they didn't operate the switch to determine whether there was lost motion.
Okay. Thanks.
So a jury may say that the switch should have looked like it did after they did their inspection, Judge, the day before Mr. Blackwell did his inspection, where everything was clean and everything was oiled and, it looked nice. And it couldn't have looked like that. And then 11 days later, looked like it did with vegetation growing and the foul ballast and the switch not operating right.
Mr. Burgess, one question. How does the condition of the ballast impact how the switch operates?
Okay, so, and I cite the Steele case, the judge has a long explanation in there, but because everything is being supported, and that's what I cite the ballast regulation, is the purpose of the ballast is to support the switch. When the ballast is improper, that will cause the switch points not to move in the right plane, not to move properly. And they have no amount of time.
You may finish your answer to Judge Lee.
So it goes into some detail in the Steele case of how the ballast can affect it. But if I could say one more thing, Judge.
And we'll give you your rebuttal time, Mr. Brutus.
Thank you, Judge.
Okay. All right, Mr. Tauber, and I apologize if I mispronounce
You got it right, Your Honor. I have 2 points to make, one legal, the other factual. I'll begin with the legal point. Contrary to what Mr. Jaranowski said in his reply brief, it is not the law. It is not the law that a FILA plaintiff avoids summary judgment whenever he or she presents any evidence of notice, no matter how slight. Like any other plaintiff alleging negligence, a FILA plaintiff must prove duty, breach, causation, and damages. In this court's 2007 decision in Coffey versus Northeast Illinois Regional Commuter Railroad, this court expressly held that, given the text of 45 U.S.C. section 51, that a plaintiff's reduced evidentiary burden is reduced only as to the causation element, not to any of the other elements. Thus, a FILA plaintiff must still present sufficient evidence of breach, duty and breach, and damages. Because notice is an element of duty, here in this case, Mr. Jaranowski must present sufficient evidence of notice. As this court has recognized following the United States Supreme Court's decision in Anderson versus Liberty Lobby, it is not sufficient to avoid summary judgment to present merely colorable or not significantly dispositive evidence.
Right. So, Mr. Tauber, let me ask you about the test of the switch by your guy immediately after the accident.
Yes, Your Honor.
It takes 126 pounds of force to move the switch.
That is incorrect, Your Honor.
Well, what did he find?
Mr. Bruges is conflating pounds, something that you lift straight up from the earth, and torque pounds. The 126 measurement is foot pounds. That measures the torque.
Okay, 126 foot-pounds of force. That's still way more than it's supposed to be, right?
No,
because
not
he
at all,
went
Your
in
Honor.
and then lubricated it and brought those forces, the foot-pounds of force back down in the 30 to 50 range, right?
That's incorrect, Your Honor. It is not the case that it was operating outside of the parameters. The parameters that Mr. Bruges points to are taken from NIOSH and some case for, I think, a different railroad, none of which is in the record and none of which applies here. The parameters for the proper operation of the switch are on the very card that the inspection report from 1026. They're at the very top, and if I think I can give you the citation specifically, Your Honor. I know it's in the opening brief. I'm sorry, I should have had it at my fingertip. But if I'll find that, or if I don't, I can give the court the citation. It's maybe it was in the reply brief, but I'll get the citation for Your Honor. But the report that shows the 126 foot-pound measurement at the very top of that very page gives the proper and actual parameters for the operation of that switch, and you will see that the proper range goes from 105 foot-pounds to 144 foot-pounds. So 126 lies well within the proper range for the operation of the switch. Moreover, Mr. Bruges simply misstated the record when he asserted that Mr. Ritter testified that the switch was not operating properly upon his inspection after the accident. Mr. Ritter testified the exact opposite. Mr. Ritter testified that the switch was operating properly. His only thing that he said about the switch looking at the photos was that, yeah, I'd have had them clean up that water bottle and paper cup. He testified that the switch was operating properly. Mr. Bruges misstated the record when he suggested otherwise. Now,
could you address this cleanup of the switch just before their expert came to see it?
Your Honor, I simply don't know why it was done, but in any event, it's irrelevant to the question of notice. The question is not what was the condition of it.
No, but it has something to do with the litigation, and it certainly sounds pretty fishy.
Again, Your Honor, I simply don't have any explanation to give you, but the question here is whether the railroad was on notice as of October 26, 2020, not whether the switch was cleaned on July 15, 2021. And understand that there are 140,000 miles of railroad in this country, almost all of which is outside. Little weeds are going to grow. Railroad tracks are not putting greens, and the FRA does not insist that we maintain them as if they were putting greens. There will be some leaves. There will be some vegetation, and it's not that you have to keep the railroad tracks pristine, as Mr. Jaranowski claims. Rather, you have to make sure that they operate properly, and they were operating properly here. Now, there's no evidence that IHB had actual knowledge of the alleged defect. The evidence shows quite to the contrary, that there were no reports of any problems with the switch from the time it was installed through the day of the accident. Mr. Jaranowski did not complain of it despite having used the switch on numerous occasions. None of his co-workers complained about the switch, and the inspection records show that it was inspected regularly as required by the FRA. Mr. Jaranowski's argument rests on the assertion that IHB had constructive knowledge of the alleged defects, but he did not present sufficient evidence that we in fact had constructive knowledge.
Mr. Talbert, what exactly does a railroad do when they inspect a switch? What do they look for?
Looks for a variety of things. We'll look for any obstructive vegetation. Here we just have a couple small weeds. It was not trees. Were there trees actually there? That would be a problem, and the inspector would note that and have it cleaned up. The inspector will check to make sure that the rails are parallel as they're supposed to be. We'll actually throw the switch during our monthly inspections. Our inspectors will operate each and every switch that they inspect, as this one. They will check to make sure that there is no need for excessive force to operate the switch. They will check the fastenings to make sure that they are proper.
Given that, what do we make of Mr. Blackwell's observations when he looked at this switch about missing cotter pins and the so-called lost motion?
Yes, Your Honor. I'll start with the cotter pin, Your Honor. If you look at the photographs taken on October 26th, the day of the accident, they do in fact show one cotter pin missing. That's true. But the fact that there was a cotter pin missing on October 26th says absolutely nothing about whether a cotter pin was missing at the previous inspection on October 15th. Cotter pins come out all the time. That's part of the reason why you're looking for them. The vibrations of the tracks means that cotter pins come loose. So the fact that there happened to be a cotter pin missing on October 26th doesn't tell us whether we had notice of a defect on October 15th. Moreover, precisely because the loss of a single cotter pin is not an urgent matter, if you look at 49 CFR section 9B, you will see that railroads have 30 days from discovery of such a defect to correct it. So even if, not the case, but even if there were evidence that we knew about the missing cotter pin on October 15th, it still would not be a violation of the regulation for at least another 30 days, because we have a full 30-day period in which to replace it.
You definitely have an answer for everything, Mr. Talber, but it still strikes me a real question here is whether the jury ought to be hearing these questions and answers and not the court. Let me take you back to another question and answer you had with Judge Hamilton about this torque force. Mr. Jaranowski responds, sure, the railroad argues this was within the manufacturer's window, which is in fact what you repeated to us right now, but it exceeds OSHA's requirements, and it exceeds the lifting requirements for conductor's job description, which would have been 85 foot-pounds, and OSHA's at 51 foot-pounds.
But they're not, Your Honor, if I may correct you, they're not foot-pounds. This is where the problem comes in.
Pounds.
The OSHA regulation, which I don't think applies here, and this case where you just pull something from another railroad, are speaking in lifting weight. So if force straight up, that's a pound. You're lifting the weight. Whereas with the torque pound, with the foot-pounds measuring torque, what you're doing is simply measuring the force it takes to move a lever 1 foot with 1 pound of energy. And that then describes the motion at the center of the rod that's being turned. And so because, as Mr. Bruges says, it's a lever, you cannot compare foot-pounds, which is leverage, to just lifting 1 pound. They're just completely separate measurements. One has nothing to do with the other. So the observation that the switch in one of the 3 measurements registered a downward motion of 120, remember that's downward levered motion of 126 foot-pounds, tells you nothing at all about, does not suggest that it's out of any spec, because the 2 specs that Mr. Bruges points to, Mr. Jaranowski points to, are in feet, not foot-pounds, and they are not applicable here. They're just not applicable. There's no evidence to suggest that either the OSHA standard or this other railroad standard apply to this switch, and indeed the switch shows that it was within proper tolerances. But frankly, Your Honor, even if, Mr. Jaranowski's argument I'm sorry, may I finish?
You may finish your thought.
Thank you. Mr. Jaranowski's argument with respect to constructive notice rests entirely on Mr. Blackwell's report. Mr. Blackwell's report says, I looked at photographs from October 26th and I see defects there. Even accepting that as true, and we certainly have quibbles about whether or not they're not quibbles, we would contest vigorously that there are no defects, but even if we assume that there are defects visible on the photographs from October 26th, that does not establish that we had notice of those defects on October 15th.
All right, thank you, Mr. Talber. And Mr. Bruges, we will give you 2 minutes.
So I guess the first issue, and the important issue, is what does the law say? Because there certainly is a long line of cases starting in 1940s from the United States Supreme Court that have been cited by this court over and over that say that the quantum of evidence in a FILA case to survive summary judgment is significantly less than in a common law case, and that a FILA plaintiff with any evidence of notice or negligence, any of the elements, survive summary judgment because a right to a jury trial is an integral part of the statute, and that's decades and decades of uncontested precedent in the FILA area. And so that's, I guess, what your first is. You're going to have to decide whether that the way I said the law and the cases I cited are correct, or that it's a similar standard to any other case. But even under a normal case, there was significant evidence. And what I would point the court to is Judge Radovich saying that arguably plaintiff has evidence of notice based upon the vegetation violations in the photographs taken the day of Mr. Jaranowski's injury. To answer Judge Lee's question, what does the track inspector look for? He looks for violation of the federal track safety standards, 49 CFR Part 213, which the photographs show and Mr. Blackwell's subsequent inspection show significant violations. So, you know, the second part that we really didn't address is whether notice is even necessary in a violation of a regulation under Kernan and Walden and Schmitz and all those cases that have never addressed this issue. You know, I don't think the Federal Railroad Administration changed, it's decades and decades of FELA jurisprudence by that small Federal Register blurb that they're relying upon. And if you look at that, they had to do a federalism analysis as part of that notice of proposed rulemaking that specifically said there's not going to be any change by this notice of proposed rulemaking to federal law. So we would ask your honors to please give Mr. Jaranowski his day in court for the railroad's violation of the FLA.
All right, okay. Thank you to
Thank you.
both of the parties in the case. We turn now to case number 5, Helen Fraser Hill versus the CTA et al. This is appeal number 22-1609. And we'll hear from Mr. D'Alba when you're ready.
May it please the court. I'm Joel D'Alba. I represent the plaintiff, Helen Fraser Hill, in this ADA case. With all due respect to the district court, there's no deference to be accorded to the district court's findings of fact. That's the law of this circuit. The circuit court is to give a fresh look to this case. All reasonable inferences are to be drawn in favor of the plaintiff, the non-moving party, on the CTA's motion for summary judgment. This is a jury question. Was she disabled? It's not the role of the court to decide if she was actually disabled under the ADA. It's the role of the court to decide only whether a rational jury, viewing any conflicting evidence in the light most favorable to the plaintiff, could so decide. The district court did exactly the opposite. Quote, "It doesn't matter whether the CTA in Hampton disputed her medical history. What matters is whether Fraser Hill presented evidence that her carpal tunnel substantially limited a major activity." That's the opinion at page 80. So the question is, did she present enough evidence? The answer is she did present evidence in terms of occupational therapy reports. The court went on to say, a plaintiff must show the impairment that substantially limits a major life activity. The inquiry is whether the plaintiff's condition constitutes an impairment, whether the activity upon which the plaintiff relies constitutes a major life activity. That goes to the merits of the case. Quote, "Fraser Hill argues that her carpal tunnel substantially limited her ability to work, reach, and lift. She points to a collection of material in the record, including doctor's notes about her work restrictions and about her pain, occupational therapy reports, and her remission to area 605, which is disability area. However, none of this evidence shows carpal tunnel substantially limited her major life activity in 2018. That's also a jury question. Let the jury decide that.
Mr. D'Alba, what is, I think this is a question for our court with our fresh look. What's the relevant time frame in your view, 2016 or 2018?
I think the relevant time frame is 2016. And here's how it started in our brief before the district court. Page 2 of the motion.
Which of your briefs?
It's the brief on the memorandum in support of the motion for summary judgment. It's docket 132-1 at page 2. First sentence of the first paragraph. medical reports prepared by plaintiff's doctor between April 12, 2016 to August 1 of 2019 consistently show she suffered from bilateral carpal tunnel syndrome, and that has been treated multiple times. I want to point out, Judge, the district court looked only at her left hand. She had carpal tunnel in both hands. This affected her for the entire period of time from 2016 to 2019. In the complaint that we filed, there are several references to the what happened in 2016. Paragraph 36, at all relevant times, she's had a disability. That includes this entire frame of 2016 to 2019. That's at page 30, paragraph 37. Paragraph 39, the 2016 alleging in 2016 the CTA was aware of plaintiff's disability since at least 2016 CTA has been aware of her disability. Paragraph 40, CTA discriminated against plaintiff by not making reasonable accommodations. Paragraph 38, at all relevant times herein plaintiff has been qualified to perform the essential functions of the job. So it's our position that this issue of 2016 is important because this is a condition that comes and goes. Mm-hmm. It's a condition, as she said to her occupational therapist in 2018 when she asked, how are you doing? How is the pain? How are the issues that you're handling? She said it comes and goes.
So your position is you're challenging the 2018 denials only, but what happened in 2016 is relevant.
Yes, but I also have challenged the 2016 matters because in a case called Mazzio, the 11th Circuit wrote regarding the statute, this is a matter that could recur.
But in your Fourth Amendment complaint, the only denials mentioned are the 2018 denials.
Correct.
And that's all that's discussed in the summary judgment briefing.
I think in the summary judgment briefing, we also referred to the issues that arose from 2016 to 2018.
You do mention it.
You disavowed the 2019 in the briefing. And then your response to the defendant's motion for summary judgment is silent about 2016.
I think in the 2016, in the early pages of the reply brief, we referred to the fact that she had problems for this whole period of time. And in a case called Mazzio, an 11th Circuit case, we're relying upon a piece of the statute that says a disability, an impairment that is episodic or in remission is a disability if it would substantially limit a major life activity when active. And what the judge did was disregard the 2016 issues, looked only at the 2018 issues, and it's our view that the occupational therapy reports show that she has these ongoing problems, and under the statute and under Mazzio, this is something that should be considered for purposes of the jury.
I can understand how the district judge might not have focused on 2016, given the way the briefs set this up. And in 2016, as I understand it, plaintiff was able to use her seniority to drive only the standard buses, correct?
She used her seniority to do that, and the supervisors allowed it to get
right. Why did she not try to do that in 2018?
They wouldn't let her.
Who wouldn't let her?
The CTA. She asked for an accommodation in February.
No. Why didn't she just ask for use her seniority to bid for standard bus routes only?
She asked that. It was denied.
Where do we have that?
It's in the record. There's deposition testimony from Ms. Hampton, and it's in our briefing. I can't tell you exactly the page, but it's there.
I understand. Well, okay. If you can tell us in rebuttal, that would be helpful, because frankly, given the briefing here, it's hard to understand what the parties are actually disputing.
Well, among other things, they're disputing whether this is an essential job.
Then I understand the question is whether the plaintiff could have simply taken care of her own problem in 2018 by doing what she did in 2016.
They wouldn't want her on the job. I will find that page. May I have the rest of the time for rebuttal?
Mr. Elba, could I just ask one question before you sit down? So she had surgery in September 2017, right?
Correct.
And her doctor deemed it a successful surgery. And then afterwards, we have this status, January 18 work status report that didn't have any restrictions on it. What are we to make of that with regard to all of the issues? It seems to me that the judge and below kind of focused on that to talk and as kind of the parameter to kind of set everything up.
Well, first, she continued to have pain. She went to an occupational therapist in April of 2018 who said that she would have trouble carrying a shopping bag and washing her back. That deals with reaching. You can't wash your back unless you're reaching. And you can't carry a shopping bag unless you're lifting. So she continued to have problems in 2018. And with respect to the 2019 issue, Judge Hamilton, her doctor specifically wrote a note that said she would be restricted to heavy lifting. So even if her accommodation request in 2019 should not be considered, that evidence should be considered in the context of this ongoing issue of remission and then ebbing and flowing, which is what the statute provides for.
Okay, thank you, Mr. Diallo. And we'll give you some rebuttal.
Thank you, Your Honor.
Additional rebuttal time. We'll now hear from Ms. Dimitrieva, and please correct my pronunciation.
Good afternoon, Your Honors, and may it please the Court. Irina Dmitrieva on behalf of the Chicago Transit Authority. Your Honors, this Court should affirm summary judgment on the plaintiff's failure to accommodate claim in favor of the Chicago Transit Authority for two key reasons. First, as the District Court correctly held, plaintiff failed to elicit adequate evidence for a reasonable jury to conclude that she has a disability within the meaning of the ADA. And second, and alternatively, plaintiff failed to demonstrate that she is a qualified individual entitled to ADA protections. Specifically, she failed to show that she can perform the essential function of her job, operating an SCTA bus with an accommodation that is reasonable on its face. First, while it is true that the ADA Amendments Act expanded the definition of disability and the term substantially limits, it is equally true that the word substantially remains in the statute. And the courts who grappled with the construction, and even in cases that plaintiff cites in her briefs, reasoned that the word substantially has to be given some meaning. It cannot be superfluous. And therefore, not just any limitation would suffice to constitute a disability. And as the federal regulations explain, an impairment is a disability only if it substantially limits an ability of an individual to perform a major life activity as compared to most people in the general population. And so applying these standards on the record as it exists right now after a full-blown discovery, no reasonable jury could find that plaintiff's carpal tunnel syndrome substantially limited her abilities to lift and to reach, which are the only functions that she discusses on appeal. To begin with, there is no medical document in the record that imposes any lifting or reaching restrictions on the plaintiff. And yet we have multiple work status reports in the record and also attending physician statements that specifically ask her treating physician to indicate whether she has any work restrictions such as lifting, carrying, pushing, pulling, overhead work, use of right or left hand. And in none of these work status reports, her treating physician checked any of these boxes.
So what do we make, at page 9 of your brief, you say, this is after she has had the surgery. Top of the page 9, you write, but because Fraser Hill had a medical restriction, the only way she could return to active duty was by seeking and receiving a reasonable accommodation.
Yes, and this is to answer your
How is that
Honor's-
consistent with saying she doesn't have a substantial disability?
And this is to answer your honest question to posed to the plaintiff's counsel, what is at issue here. The only medical restriction that your physician imposed is not to drive articulated buses. And so when she submitted the request for reasonable accommodation supported with this restriction not to ride articulated buses, the Accommodations Review Committee followed up with letters to her physician asking, can you please explain what exactly prevents her from driving an articulated bus? Because our instructions department, and bus engineering department informs us that it's the same, driving both buses. And so the medical restriction here is not actually illuminating on the functions of her, on her physical functions that are restricted, because it says she cannot drive the bus. That doesn't explain anything as to what function of her body is affected, and that was not explained, because what she is arguing here is lifting and reaching.
I understand that, I think, so far, but it sounds like your committee, though, was saying, well, if your doctor says this, then you can, and we have to respect that, then you can't drive articulated buses. Right?
That's yes. I mean, there's case law. I think that's clear that if there is a restriction not to do certain things coming from a doctor, we have to respect it.
Right. And so maybe this goes to your second point, but that, I mean,
But
if she's got a doctor telling her, and you all are saying, we can't give you certain work assignments.
Right, but driving an articulated bus is not a major life activity. I mean, they pursued an argument below saying she's restricted in the major life activity of working, which the district court held under the law. Evidence is not sufficient because she's not restricted in working. She wants to work as a bus driver. She affirmatively states, I can drive a 40-foot bus. I just prefer not to drive a 60-foot bus. So what function, what is major activity, we're talking about here? The only major activity that your restriction relates to is driving an articulated bus, which is not a recognized major life activity.
I didn't take the CTA's response to the medical restriction letters to be, since you have this medical restriction, you can't drive articulated buses. I took the CTA's response to be, since you claim to have this medical restriction, you can't drive buses at all, because we can't divvy up articulated,
Yes.
non-articulated.
Yes, and that is the position that if she's taken at her word that she in fact cannot drive an articulated bus, it is an essential function of any CTA operator to be able to operate any bus in the CTA fleet.
Why is that?
But we
I'm
have
very
take-
troubled by that argument because we have repeatedly rejected such arguments, including involving bus drivers. In a case
Well,
called Brown against Smith.
Yes, I'm aware of your order. In Brown v. Smith, it involved the street supervisor of City of Anderson Transit Authority. And there was evidence in the record that it was not his as a primary duty to drive buses. In fact, he was a supervisor and he worked for 4 years without ever driving a bus. So consistent with EO interpretive guidance on what is a reasonable accommodation, marginal duties of position could be restructured and reallocated, but the law does not require an employer to ever reallocate essential function of the position.
That begs the question.
Yes,
right?
an essential function of the position, according to Code of Federal Regulation, is the principal function for which the position exists.
Right. Now, the question, though, is we've had repeated cases, and Brown against Smith, I appreciate your command of the specific facts of that case, but the more general principle, in essence, is that the ADA requires some flexibility of employers in figuring out even what is an essential function. We have repeatedly dealt with employers who have said, in essence, our jobs as managers are a lot easier if every employee is able to do multiple jobs, right? And we've said, no, the ADA requires you to do an individual evaluation. Miller against Department of Transportation, Tate against DART addressed this.
And that situation involved teamwork. What we have here, Your Honor, is not teamwork. Each person,
right.
As a
So
part
what about the situation in 2016 when she's just using her seniority to drive only standard buses?
She came to work without any medical restriction, so she was cleared to come back to work with no medical restriction, and then she exercised the seniority rights
So why couldn't she do that in 2018?
If she did not have any medical restriction, she could. But she did have medical restriction, and what she herself testified is that, and what is important to understand, as a part of the collective bargaining system-wide pick process, bus operators pick a route. They pick a garage and a route. They don't pick a specific bus. Right. And the evidence in the record is very clear that it's not uncommon. So what happens is that the bus operators come to the terminal every morning before their shift, and the dispatcher assigns them a bus. And the type of the bus that gets assigned depends on customer needs. Ms. Fraser-Hill testified that, for instance, in December 2015, when she did pick a route based on her seniority that ordinarily operated only standard buses, she nonetheless was required to operate longer articulated buses in the morning. So 20% of the time she operated articulated buses, 80% of the time she operated standard buses. She also testified that even if she picks a garage route that normally operates standard buses, if they assign to her an articulated bus, she has to do it. And in her reply brief, her solution to that issue, that just exercising her seniority right does not solve her problem. Because even if she picks a garage, she picks a route that ordinarily does not operate normal buses, and the evidence is undisputed that all bus operators are trained and expected to be able to operate articulated buses. So I think on page 20 in her reply brief, she acknowledges that if the CTA were to replace a standard bus on her route with an articulated bus, she would have to swap shifts with a different employee or to take paid time off to avoid driving the articulated bus.
So what is Ms. Fraser-Hill to do? Because she's in it's more than a catch-22. She's caught on three sides. Under CTA's rules, she can't work if she's got this medical restriction, okay? And she can't use her seniority to just drive the type of bus she wants to drive because of the restriction, the medical restriction according to CTA. And then ultimately, after she exhausts the 3-year process, the name is escaping me, where you're on this kind of disability leave.
Area 605.
There we go.
Yes.
Then she's not called back to work, but yet she can't get a disability agreement from CTA because CTA doesn't agree that she's disabled based on this carpal tunnel. I mean, it's in court contesting.
No, that is not clear to me.
CTA's position in court is that she's not disabled because she's not substantially limited in a major life activity of reaching or working.
Right
That's
now,
all I'm
yes,
referring to.
Yes.
That's all I'm referring to.
Yes. Well, our position is based on the lack of any medical restriction on her lifting or reaching ability, none. And so it's based on the documents. And there is a lot of evidence that obviously, the cherry pick. For instance, why they didn't want to introduce any, in the summary judgment, they wanted to prevent us to cite any medical documents from 2019 because they show 0 functional limitation, grip strength 5 and 5 bilaterally. So there was a specific job-specific occupational therapy evaluation done in December 2019 that showed zero functional limitation in gripping, lifting, reaching. She could do everything. The grip strength was 5 by 5. So she, but we don't want to go there because, she argued below this, medical evidence from 2019 should be inadmissible because it's beyond the scope of her complaint. Now, when it's convenient to talk about disability, she wants to cite maybe some, random medical document from 2019 that does talk about a certain limitation, but the position remains that limitation has to be substantial. There is absolutely zero evidence on which a reasonable jury could conclude that a limitation, like if we take the evidence in the light most favorable to her, those two occupational reports possibly say there was a limitation, but they don't illuminate whether that this limitation is substantial as compared to most people in the general population. So yes, there is no disability. I mean, the only way to answer Yona's question for her, which was discussed over the years at multiple points in time, is to do the same as she did in 2016, because is to come back to work without any medical restriction and to exercise her seniority rights. But if we're taking her and her physician at her word that somehow the vibrations in the bus, affect her, then she would have the same problem with the 40-foot bus, because she was asked in her deposition, we're here dealing with Chicago streets, there are bumps on the road, would it cause vibrations? Like, yeah, it would cause vibration on standard bus too. And standard buses, they could be newer, they could be older, there could be all sorts of issues that could, cause possibly vibrations and stronger gripping on a wheel. So for us, for the CTA, so her doctor is saying it's a problem for her, with vibration. Well, that could be the same problem on a standard bus as well.
Thank you.
Thank you. I'm sorry I exceeded my time on this.
Mr. D'Alba, we'll give you the 3 minutes.
First, the substantial limitation question is really a jury question as to how bad things really are. In answer to Judge Hamilton's issue, here's what happened in 2016. Her own doctor said you can go back to work, you should only be driving the standard bus. Their doctor said you're medically cleared. At the same time that their doctor said she was medically cleared, the Accommodation Review Committee said, we're not going to give you an accommodation because you don't have the appropriate medical basis to come back to work. So how is a jury going to deal with this? There are 3 inconsistent issues with respect to how she went back. She goes back to work, she starts driving a standard bus for the next 11 months. Her supervisors know about it, and nobody cared. Nobody objected to it. In terms of where she could drive, she was asking in February, and that's on page 20 to 21 of our reply brief. She went in and said to Ms. Hampton, I want to go back to work. Ms. Hampton said, Fraser Hampton said, I want to be able to pick a garage that doesn't have articulated buses. At that time, there were 4 garages that didn't have articulated buses. She could have driven garages from Forest Glen. She could have driven buses from Forest Glen. She could have driven buses from Chicago Avenue. And so what did Hampton say? Hampton told me I would not be back. I won't be able to pick. Hampton didn't got me a reason other than to say if I can drive a bus, I can drive both buses. And there's a factual question as to whether or not it's essential to be able to drive, essential job function is to be able to drive both buses. With respect to the question of bus routes, undisputed, there are about a dozen bus routes that do not take articulated buses because of the narrow turns. She could have driven on any one of those. With respect to the question of medical restrictions, her doctor consistently said, don't want you driving an articulated bus. And they just said, we think you should be able to drive both buses. And that's a factual question as to whether or not that's an essential job. It's a question for the jury. There's a section of the CFR at 1630.2J II. I'm going to quote, the primary object of attention in cases brought into the ADA should be whether covered entities have complied with their obligations and whether discrimination has occurred, not whether an individual's impairment substantially limits a major life activity. Here the judge said it was substantial, and that's a factual question. He took it from the jury, and I think that's why this case should be reversed. Thank you, Your Honor.
Okay, we thank both parties. This brings us to our final case of the day, appeal number 22-1926, United States versus Paul Erlinger. Okay, we'll hear from Ms. Cook when you're ready.
Thank you and good afternoon. Paul Erlinger is currently serving a 15-year sentence in the Bureau of Prisons. That's the mandatory minimum penalty for a felon in possession of a firearm whose sentence has been enhanced as a career offender, an armed career offender. The government concedes in this case that following the Supreme Court's decision in Wooden, the Sixth Amendment requires that a jury determine whether ACCA predicate offenses were committed on different occasions. Further, the government has recognized that ACCA's different occasions inquiry that is required by Wooden does not fall within Almendarez-Torres's narrow exception, the simple fact of a prior conviction. And the government concludes, as we urge, that a Sixth Amendment violation occurred in Mr. Erlinger's case. But having conceded that there was a Sixth Amendment violation, the government then argues that the error in this case was harmless. Because Mr. Erlinger raised the Sixth Amendment issue prior to sentencing, in fact, he raised it as early as 2018, the government's burden is proving that the error was not prejudicial. Unlike the defendant in the Rodriguez case, which was submitted by the government as supplemental authority here, Mr. Erlinger never waived any objections to the Sixth Amendment issue. As early as his original sentencing in 2018, prior to the Wooden case, he objected to the court's fact-finding, raising the Sixth Amendment issue.
So, Ms. Cook, what would this jury trial look like?
Well, the government would have the burden of proving that the predicate offenses which they allege were committed on occasions separate from one another. I assume they're going to have some difficulty in this case. These are 30-year-old offenses, and they have very scant documentation that would prove when and where these events occurred. But a jury would be tasked with making a determination as to whether there were three separate occasions represented by the predicate offenses.
So would Mr. Erlinger, for example, the government puts the records in that charge these different burglaries on different locations, different days, and Mr. Erlinger takes the stand and says, no, I did them all the same day, or I'm trying to imagine what this looks like.
Well, I think there are a number of different possibilities. One possibility is, if it were true, he could testify that they occurred on the same day. Otherwise, he might rest on his right to remain silent and put the government to its burden of proof. I think one of the issues in this case which distinguishes it from many of the other ACCA enhancement issues is the fact that these convictions were Indiana state convictions. And in Indiana, the location of an offense and the date that is alleged in the information are not elements of the offense. Even though they are in the charging information, they're statements that we call non-elemental facts. Mathis refers to non-elemental facts in the records of prior convictions, and in fact, the Supreme Court in Mathis notes that those kinds of non-elemental facts, such as in Indiana, location and date, are prone to error.
So then, just going back to what the trial would look like, the defense would raise these kind of unreliability arguments that you raised in your brief, raise those for the jury.
That is one possibility, yes.
And so, I'm sorry, go ahead.
Let me ask you this. If the government concession is quite nice to have, I imagine, for Mr. Erlinger, Is it your position that the district court is bound somehow by that concession in the face of our Seventh Circuit precedent, like Elliott, that says it's okay for a judge to make this decision? And what's your position on whether or not Wooden affects that precedent? Because the concession is only part of the picture here.
That's correct. And the district court believed that she was bound by the Seventh Circuit precedent and believed that she was bound to make a finding of separate occasions based on the dates that were in the charging informations. That was not our position at the district court, and I believe the government's position at this point in time is now we look beyond that Sixth Amendment issue, which we concede is an error, was an error in the district court, to whether or not that error was a harmless error or not.
And so you agree that harmless error is the standard. Your argument is just that there is harm.
Yes.
Yeah, okay.
Did the defendant, Mr. Erlinger, ever dispute the dates or locations that are reported in the pre-sentence report?
He disputed at each step of the proceedings the allegation that he had committed those predicate offenses, and in fact the government at one point alleged that there were 4 predicate offenses but couldn't find a judgment of conviction for one of them. He disputed at every point that those incidents had been committed on separate occasions.
Did he dispute the facts and locations?
I don't think it was incumbent on him.
That's not my question. I understand that's your view. But did he, if we might disagree with that, did he dispute the facts as alleged?
He never testified that he committed the crimes on separate occasions or in separate locations.
He never disputed that he did. Sorry, he never disputed the charge dates and locations, did he?
He disputed them legally. He did not take
Ms. Cook, I don't want to fence with you about this. I understand your legal position. And I don't know what I think about it ultimately, but if I disagree with it, then the question is there actually anything to be tried here? I haven't heard any indication that he has ever disputed any of those charged locations or dates.
He never testified
or in any other form disputed
that's
those.
correct.
He admitted it.
Thank you. The issue only comes up at resentencing, though, because the government keeps changing which predicates it's relying on throughout the proceedings. So these 3 burglaries only become an issue at the final resentencing. And that's when Mr. Erlinger mounts this dispute. These aren't ACCA predicates in my book, am I right?
Yes, Your Honor.
Okay, so this is not some long-standing, long-running dispute about these 3 burglaries. This is a new issue.
Well, he disputed the court's right to make a factual determination as a violation of the Sixth Amendment back in 2018 when there were 2 burglaries and another.
Yeah.
Another offense.
With regard to these predicates, though, in the underlying case, when Mr. Erlinger pled to those charges, as part of his plea agreement, he admitted to all of the allegations made in the indictments, did he not?
They were charging informations under Indiana law, and he pled guilty to those 3 charging informations. There was a document that was attached that he signed, which is boilerplate. I mean, he signed something also saying that he would testify against his co-defendants when he had no co-defendants. It was just boilerplate. He signed a document saying that he had been advised of the minimum and maximum penalties when those were left blank in that document. He said he had been advised by one attorney when another attorney signed off on that document. Yes, he said that he admitted the facts. There's no transcript of any colloquy with the court where he is specifically making any admission to location or date. And again, I would just note that, this is the Mathis problem. This is the same issue that Justice Gorsuch referenced in the Wooden opinion when he says there's this constitutional issue that's simmering under the surface of the Wooden case. It never was addressed in Wooden because Mr. Wooden didn't raise the constitutional issue. But Judge Gorsuch recognizes that, you know, if a jury has to find these facts, how can a judge impose punishment without equal certainty about the law's application to those facts? I think I'm out of time.
All right, thank you. Mr. Reitz, and you can correct me on the pronunciation.
You're correct, Your Honor. May it please the Court, Brian Reitz for the United States. Any error here was harmless because Mr. Erlinger's burglaries were committed at different locations on different dates. I think using a hypothetical trial is maybe a good way to look at this and why that's harmless. So at a hypothetical trial, we would admit the charging informations and Mr. Erlinger's guilty plea, where he signed that he agreed that the facts as alleged in the charge.
But why ought if Mr. Erlinger is saying there are lots of things I can tell a jury about the unreliability of those documents. Government thinks those Indian documents are reliable. I don't. There are things I want the jury to know. Why should he not have the opportunity to tell a jury that?
So I don't want to argue with our concession that a jury is required, but at least to a fact finder, Mr. Erlinger had that opportunity when he went in front of the district court, and he has not disputed that the locations or the dates were incorrect. He has not cast any doubt why these particular documents were unreliable. So when the court here is looking whether the error was harmless, we have a play of what would have happened, and Mr. Erlinger said nothing.
I think the blue brief is full of Mr. Erlinger saying why these documents are unreliable. And that he, appended to these or also in the file are a bunch of documents I signed with information that doesn't match up, and these time and place are non-elemental, and there are reasons you might not challenge them in India State. So I don't know that your idea that a proxy of what happened before the district judge is good enough for what might happen in front of the jury when he did plenty in front of the district judge.
So I disagree that he did plenty, Your Honor. I think he made general objections about this, but he never disputed that the locations and dates were inaccurate. And he had the opportunity in front of the judge. The judge could have found something different if there had been some reason that Mr. Erlinger gave that was credible, why the dates and locations in the charging informations and his guilty plea were incorrect. But he never did. So we're in this hypothetical world that maybe Mr. Erlinger would be able to find some evidence or introduce something that would undermine it. But what we have in the record, a rational jury, which that is the test, a rational jury is going to rely on the certified court documents in the face of, I guess, attorney arguments at closing. That's basically what happened at sentencing. We had actual evidence from the government and attorney arguments from the defendant. And there's no reason to suspect at a trial anything different would happen, and nor has anything been alleged here.
Mr. Rich, I want to ask you the question that one of the questions that Judge Hamilton asked Ms. Cook, which is, what would a trial like this look like? Where, let's say, the predicate crimes were not pleas, but they were jury convictions, okay? And a jury is told, at least in this district, that when an indictment says on or about, it might not happen. It doesn't have to be on that exact date. It could be on or sometime about, right? And so the government would presumably enter the indictment. It would enter the verdict, but it would have to enter more, right? And perhaps, let's say there's, in this situation, let's say there's 3 predicate crimes. And so then would the government basically retry the 3 prior cases?
No, Your Honor. I don't think it'd be that complicated, but I think you could have situations where we call an officer, the person that arrested him, maybe, in this case, perhaps a patrol officer that says, I patrolled Jasper, and I can tell you that these locations are 5 miles apart, 4 miles apart, 3 miles apart. So I think there's a number of things we can do. Now in this case, frankly, I think it would be difficult. It is old, so it likely would look like just the charging documents. I don't want to say anything that we would have more evidence than what we have. But I think a lot of trials we would have more evidence than just the charging documents. And sometimes the charging documents would be sufficient, sometimes they maybe wouldn't be. Here you get close to that. If all 4 burglaries were on April the 4th, I think that would be really hard without more information. That's why the district court only considered that as 1 burglary. But in that situation, we might need to call someone else to explain what happened. There'd be many witnesses. There could be the victims, the officers. It's like any trial. I think it'd be open field for anything that was admissible under the federal rules of evidence. If there are no further questions, we're happy to
I'm
address.
just trying to imagine welcoming prospective jurors and imagining how I would instruct them as a district judge on this question.
I think it would have to start with having bifurcated trials, which would make it a little bit easier.
Well, the government's obviously interested in this because it's adopting a new position all across the country that this is a jury question.
Not only that, it seems like also kind of a backdoor's way of getting in prior convictions, right? Older convictions. I mean, because if you do ask for an ACCA, right, without that enhancement request in the indictment, right, then prior crimes would be governed by Rule 609, right, prior bad acts, right? But if you say that if you start bringing in predicates, then all of a sudden those convictions become centrally relevant to the prosecution. And any arguments by the defense with regard to prejudice would basically more or less go out the window. And so that does raise rather difficult issues when it comes to how a court should treat prior convictions.
I think most of that can be resolved by bifurcated trials, Your Honor. Now,
bifurcated trial?
Yeah, you have a trial, and say Mr. Erlinger, if we go to trial, we convict him of the 922G offense. The jury comes back, and then we try him on the ACCA predicate. So of course, there's some prejudice always with introducing prior convictions, but the prior convictions at that point are the only relevant thing the jury is supposed to be looking at. So I think the prejudice is a lot lower. It's certainly not unfair at that point in time. And maybe there are cases you can redact the type of crime. I think that it's questionable. Now, all this may be a reason that we would encourage the court just to decide on harmless error. This is an issue that's percolating. The Eighth Circuit just granted en banc, and so they're maybe going to decide something. I think here, considering the documentation the government admitted, harmless error is the easiest way to resolve this case.
This new guidance from the government, this new position, it was post-Wooden?
Yes, it was a reaction to Wooden. It was actually, in fact, post Mr. Erlinger's sentencing hearing. And post, as of Friday, I haven't checked since Friday, as of Friday, post every circuit court opinion on this subject.
Okay.
But maybe something happened yesterday. I maybe should have looked last night, but I did not.
Okay. Thank you.
Gotta stay alert. Okay.
Thank you.
Thank you, Your Honor.
Okay, Ms. Cook. Yes, you can have your full rebuttal time of 2 minutes.
So one of my concerns here is that it sounds like the panel is equating occurrence with date. The government is arguing that they're going to be able to prove these specific dates, but that's not what Wooden is talking about. Wooden is talking about an occurrence as opposed to a date. And in fact, when the government's argument is all about the allegation that Mr. Erlinger's burglaries were temporally and locationally distinct, those are the questions for a jury and not for a judge in order to comply with the Sixth Amendment. But in Wooden, they talk about the fact that historically offenses have been treated as occurring on separate occasions if a person committed them a day or more apart or at a, quote, significant distance. But Wooden also recognized and said, of course, there will be some hard cases in between, as under almost any legal test. And Gorsuch, in his opinion, went on to say that offenses that are separated by substantial gaps in time or significant intervening events usually occur on separate occasions. But what accounts as a substantial gap or a significant event remains unexplained. So that's a jury question. It's not just the question, did Mr. Erlinger commit these burglaries on 3 separate dates, but were they 3 separate occasions? And a jury could find that there was some continuous activity that connected these. A jury would have to be instructed that they have to parse out these hard cases in between and look at whether the gaps in time are substantial or the intervening events are significant.
Can I ask you about Kirkland, our Kirkland case? This was 2012. And the district court looked at information, the state court information, judgments, plea questionnaires, when it was trying to decide if the defendant committed the felonies on separate occasions. And it was tough in that case because, you know, the burglary and the robbery, 2 of the 3 predicates, were committed on the same day. So the judge was trying to figure out, you know, separate occasions or not. And we found the record was insufficient in that case.
Yes.
Okay? Here, the district court relied on similar documents, you know, information, judgment, plea, you know. But unlike Kirkland, the information's clearly state different days, April 4, 8, 11. So how does our decision in Kirkland affect the analysis in your view?
Well, I think what happened in this case was the judge considered both of the government's arguments. She considered the location argument and rejected it, and found that the location argument was not proven by the government and no documents were sufficient, and she focused then simply on the temporal argument and believed that she was constrained to follow the Seventh Circuit's decisions despite the Wooden case. And that's what she relied on. And of course, the government in that case, you know, you talk about what kind of evidence they would introduce. They wanted to put in Google Maps for the judge to look at, which she, of course, rejected.
Why not?
Well, because this is
We've used maps.
we may have used maps, but these incidents allegedly occurred 30 years prior, and there's nothing to say that the Schnitzelbank restaurant's located at the same place today that it was then.
I think I ate there 30 years ago.
May have. I mean, I think this is the question that's underlying in Wooden. And when we talk about harmless error, I want to just make one other point, and that is that the Rodriguez case collects a number of different harmless error cases. But one thing that's significant in some of these harmless error cases is the Seventh Circuit and other circuits' view that we can look to what the judge would have done but for the enhancement. Because in many of these cases, the judge is saying, I would vary upward and give the defendant 15 years. In this case, our judge specifically said in 2018 and again in 2022 that she thought that this sentence was not fair, that it was unduly harsh, and if the case came back to her for resentencing, it would be a 5-year sentence and not a 15-year sentence. So I think that goes to the issue of lack of harmless error here.
Thank you, Ms. Cook. Thank you to both parties in this case. And that concludes our arguments for today.